Motion.
Obliged.
Similar payments.
Similar payment.
With regard,
19, my lord.
No. Tomorrow.
19, tomorrow.
Tomorrow.
with regard to item number 44, my lord.
40.
44, that yesterday's matter, my lord. Appeal against capital.
Hmm.
That we'll have to withdraw, my lord. We have to file there, my lord.
Have you got through?
I've gone through seriously.
Okay. Mr. P.K. Muni, Learned Counsel for the petitioner, has submitted that the criminal petition as well as the accompanying criminal appeal may be allowed to be withdrawn in order to avail appropriate remedy of appeal before the jurisdictional appellate forum. In view of the
Some observation regarding section 14, summary election.
so I have to open the file. You be there then. In view of the decision of the Honorable Supreme Court of India in Mallikarjun Kodagili and Celestium Financial Silo. In view of the above submission made by Mr. Munir, Learned Counsel appearing for the petitioner. No. Yes, negative. Celestium Financial versus A. Guno Khana Pekaran 2025 INSC 804. Before the jurisdictional appellate forum, in view of the submission made by so-and-so, the criminal petition along with the accompanying appeal are dismissed on withdrawal with the liberty, as paid for.
Lordship, I beg to mention for item number 22, Lordship. In this case, Lordship, we have applied for some certified copies related to case, Lordship. Matter may be adjourned today, Lordship.
Okay, on the prayer of Mr.
H. Rahman, Lord.
H. Roman, Learned Counsel, appearing for the applicant appellant, place the case on a date immediately after the
January last-
ensuing winter vacation.
January last
TCR is
date,
there.
Lordship.
TCR is there. For what? This is for suspension of sentence.
Lordship.
Okay, list the case on. Did you?
Lordship for listing motion tomorrow.
We have this Lordship. Lordship, I beg to mention item number 13, Lordship.
13.
13, Lordship. Matter may be possible for the day.
Okay, on the prayer of Miss
A. Khan.
A. Khan, Learned Counsel for the petition, the case is passed for the day.
Item number 33, my lord.
33.
The consent of the other side, my lord, can it be in the second week of February, my lord? The
Okay.
private respondent has appeared, my lord.
Okay. On the prayer of Mr. B. Gugoi, Learned Counsel for the petitioner, released the case on
Second week of February.
February DDB. It is submitted that consent has been taken from the Learned Counsel for the respondents to make the prayer.
But there is an interim that may continue, my lord.
The interim order, if any, shall continue till the next date of listing.
Obliged.
I
Second week.
pay for adjournment
Second.
of item number 37.
Yes.
The engaged counsel went to Arunachal for another case.
You are for appellant,
No, respondent number 1 and 2.
1 and 2.
Mm.
You are Miss Anchori, Learned Counsel for the appellant is present. Miss
P. Chaudhary.
P. Chaudhary, Learned Counsel on appearing on behalf of Mr.
A. Sahad.
A. Shahad, Learned Counsel for the respondent number 1 and 2, has made a prayer for IGMA with the consent of the Learned Counsel for the appellant post of, as agreed to by the Learned Counsel for the parties, list the case on in the month of on a date in the month of February 2026.
May I please, Lordship? My lord, I beg to mention item number 38, my lord. That may be
38.
taken out after vacation, my lord.
38.
My-
This is not maintainable. Not maintainable. Yesterday, that is why you were not there. So I did not dismiss it. Next,
May please your lordship, I pray for listing of a motion matter, criminal petition.
tomorrow.
Obliged.
May I please, I beg to mention for listing of a criminal revision petition, my lord, for admission,
Race
for admission, my lord.
after vacation.
Yeah, Bishop, for listing your lordship after
Can you take-
vacation, your lordship, the first month of January.
With the concern of Azad, I beg
32.
to be adjourned for
You are for appellant.
respondent number 1,
Respond number 1, Ms. Smith
S. Boshak.
S.
Boshak.
Boshak, learned counsel for the respond number 1. Come out with the consent of the learned counsel for the appellant. Kama has made a prayer for adjournment. So stop, release the case. Prayer is allowed, release as sought for. Kama, release the case and on a date in the month of February.
I please, I'd like to mention item number 8. Matter may be after vacation, Lordship.
Okay, on the prayer of Mr.
B. Borgua on behalf of SG Borgua.
Learned counsel for the petitioner, raise the case on
7-1.
Lordship,
May I please? Paying for listing of a
phrase,
criminal petition.
phrase, new,
Yes, motion. No, not fresh. Actually, it was.
after vacation.
May I, Lordship, I want to mention item number 40 from supplementary list.
40.
Yes, Your Honor. We want to withdraw this case.
Okay. Mr. Miss
Miss Shikha H. Talukdar.
H. Taludar, learned counsel for the petitioner, has submitted on instruction. Command the petitioner wants to withdraw the petition. Oh, sorry, criminal petition. Is in view of the above submission made by so and so, the criminal petition is dismissed on withdrawal.
May I please, your lordship? Lordship, I beg to mention for listing of a criminal petition, your lordship. Lordship, can it be listed on after vacation on 6th of January, your lordship?
Okay.
Obliged, lordship.
6th of January, why? No, 6th of January.
Maybe 7th.
Seventh.
lordship.
May I please your lordship, I am praying for listing in criminal petition. on
New.
Criminal.
New petition.
Pending.
Oh, give it to the court master.
7th
Give it
January.
to the court master.
Yes, Lordship, I want to mention regarding item number 5 of the daily list.
5.
Yes, Lordship, matter may be adjourned for the day, Lordship, as learned counsel P.K. Chaudhary is not well today.
On the prayer of Miss
You, Nanda, Lordship.
Yunanda, learned counsel for the petitioner, hers, raise the case. On, so.
Obliged.
19,
Please, Lordship.
19-1.
May I please, Lordship? Item 7, Lordship.
Item
7,
7.
Lordship.
Yes.
Adjournment for today, Lordship. After vacation, Lordship.
Okay. On the prayer of Mr. Miss so-and-so. Yes, name,
Ms. J. Akhtar.
raise the case on so-and-so.
1.
My lord, I am praying for listing a bail application on Friday.
Oh, bail is not before this court.
Posting was 4/11.
Anything rejected by me?
No, my lord. Obliged.
Similar prayer for listing, my lord, day after tomorrow.
What, bail?
AB, my lord, NDCP.
Rejected by me earlier?
No, your
Then go to the appropriate bench. This is not bail bench.
Daily list for motion, item number 1.
नहीं हमारा bill तो नहीं. By the volume, I am scared.
no, we will not go for we have made it only easier so that your Lordship will kindly go directly to page 684.
684.
Because it said, started with
It is in which volume?
680, volume 3. Your
This is
Lordship-
the impugn order.
Yes, no, this was the order which was challenged before the session court by both the husband and the wife. Now your Lordship will see the 6th line, as the respondent number 1 is already voluntarily paying rupees 10,000 to the aggrieved for her maintenance. Hence, in addition to the voluntary contribution of rupees 10,000, The respondent number 1 is further directed to pay a monthly allowance of rupees 15,000, 15 only for the interim maintenance of the aggrieved party by the 10th of each month. The said monthly allowance shall be payable from the date of filing of the interim maintenance petition. To that extent, my lord, there was nothing wrong in this, but we had gone to the session court for enhancement of this maintenance amount. This order was stayed in the session court on 29/1/2025. Now, by the impugned order, your lordship will kindly go to now page 710, the operative portion. Our application 710, your lordship got it?
Yes.
Our application for enhancement is dismissed. That's why it is written in bold.
Hmm.
Now, so far their petition is concerned, that order your lordship will find at page 699. Para 19.
Hmm.
Now, I was getting 25,000 without any justification, without any discussion. Now it has been made only 15,000. So we are seeking stay of this order, my lord, till the disposal of this revision petition, because I was getting 25,000. And my flat rent, which I am staying, I have to pay in Hanganabari 35,000. That's another issue, because both this family belong to well-to-do families of Guwahati. The husband has taken all her properties, which was given to her by father, and converted into his name, given on, taken loan against those properties. So now she is in extreme distress, my lord. That's why,
No. Come to page 684.
yes,
It was an interim maintenance order. It was an interim maintenance order.
no, 684, yes. Yes,
So there, the court recorded that 10,000 was voluntary.
voluntary. So that's why court fixed it,
And
15,000
15,000 was in addition to.
addition to. So I was getting 25,000. Now that voluntary part has been, no observation
You
on.
sought an enhancement.
Yes,
That appeal was dismissed.
yes,
And they also preferred an appeal.
appeal.
What is the meaning of this page 699?
699.
The appellate court touched 10,000.
No observation on that.
Huh?
No observation. They says appellate court simply gave a finding that 15,000 will be continuing to be paid.
No, what about 10,000? Any discussion?
I know. Just a moment, man. I'll. Your lordship may see paragraph number, paragraph number 710, paragraph 17. 710, page number 710. Para 17.
That 710 paragraph.
Where my appeal was dismissed, my lord. 710, my appeal, the 25% of the above amount would be around rupees 25,000, but the respondent has already been directed to pay rupees 20,000 as the alternative accommodation, which has been upheld by this court. As such, at this stage, we cannot impose any more monetary burden until the proof of actual income of the parties.
No, what is that? This is what? This 25,000 earlier interim maintenance, there was something more, 20,000?
That was for alternate accommodation because the flat rent was 30, in Hanganabari, I think it's around 30,000. So court, and she was thrown out of her own property. That's why the court gave 20,000 and 10,000. The court said you manage.
This amount is under which section, DV Act?
Yes, sir. Under DV Act section 19. So, monetary relief 20. Your lordship will look at the power to grant interim is at paragraph section 23 of the DV Act. এখন দিয়ক
allowed
এখন দিয়ক
for
মোক পালে দিম
hereby already set aside, which is
এখন-
criminal appeal 13. What is criminal appeal 13?
ক্রিমিনাল এপিল 30 টো কহ বুঝিয়া পেজ নাম্বার কি কহ ক্রিমিনাল এপিল 32
Of 2025?
30
The order, what is the order? What is the order this for?
কোর্টে কি কইছে your lordship is requesting for my
Interim maintenance prayer. Into section 20.
Section 23 is the grant of interim ex parte orders and 20 is the monetary relief. He is a 20,000 টাকা ভলান্টারি দিয়ে আসলে এটা কোন প্যারাগ্রাফ আছে দিয়ে কোন পেজ নাম্বার আছে Basically, your lordship knows that the maintenance amount is fixed in terms of section 20 subsection 2. Because for some, the accommodation may 20,000 may look big, but it is ultimately that it should be with the standard of living to which the aggrieved person is accustomed.
So 10,000 plus 25,000.
21.
That is 27/12/2024 in DB case number. That is interim maintenance under section 23.
Yes.
So 2 appeals were filed.
2 appeals were filed.
One by the petitioner,
Yes.
that for enhancement,
Yes, that was dismissed.
that was dismissed. And they are seeking reduction
Yes.
as merit partially allowed.
The husband was voluntarily not paying, he was paying 20,000. If that he has filed an affidavit stating
Allowed the
that
prayer
fact.
for interim for the agreed have a set aside. Has been set aside, I was directed to pay 15,000. So instead of 25,000, 15,000.
And if your lordship looks at page 642, there is a statement of the husband that he is voluntarily paying 20,000.
Now, whether there is any discussion about 10,000?
But that only that paragraph, my lord,
No.
paragraph number 17 at page 710.
No, that is alternative accommodation.
Yes, only that much, nothing more.
Huh?
Nothing more, only that because the court is saying that the husband will be
No,
overburdened.
in this page 699 order, it starts from, I think, which page?
Just a moment, just a moment.
It starts from 691.
Yes, Madam. Your lordship will find it starts from
691.
691.
Now,
So-
whether that
Now,
regarding,
your lordship will find the discussion from paragraph number 7. Now,
just
at
find whether
paragraph
directed
number,
per month.
paragraph number
along with voluntary just paragraph 11.
to 12.
12. There is there.
Now, let us find out whether the amount directing the appellant to pay rupees 15,000 per month for interim maintenance along with the voluntary contribution of rupees 10,000 is justifiable or not. The admitted annual income of the applicant is rupees 10,35,194 only as per his income tax return of 2023-2024. And the income of the aggrieved party during the financial year 2020-24 is 5,43,860. It appears from the impugn order that rupees 25,000 has been ordered to pay as an interim maintenance. The monthly income of the applicant would be around rupees 80,000. 25% of the amount would be 21,000. Now, this formula, straight formula, is not applicable. You have to decide the assets and liabilities in terms of Neha judgment. Then only you can come to that.
But that is, this is for interim.
Yes.
That Rajneesh and all.
But nowadays the court, if they want, the court can ask for the assets and liabilities of both the parties to alter the maintenance.
Accommodation incurred by us. The question is whether not whether it's correctly a condition is expected.
And the court even
Admitted
did
our
not
position.
discuss, your lordship will find from page.
Income is around 10 lakh. It also appeared during however, other sources of income are limited. And what is the appellant? Because of the source of handle. Did not however.
Indeed.
So calculation has been made, rough calculation has been made.
Your lordship will kindly see page number 469.
Because that is, that interim order you pray for is allowing the judgment to sit at naught.
469.
469 means another volume,
Yes, ma'am. Volume
Huh?
number?
another volume.
Volume number 2. Highly contested case by the husband because he has taken all the properties of the wife. She had a parlor, building. Now he has taken loan against those properties, madam. 469, your lordship will find his total expenditure. Your lordship got 469. Now your lordship will find at CL number 60, the total expenditure is 29,39,967. And at 58, when I was with him, then he is showing that he is giving me pocket money allowance of rupees 20,000 per month to the wife. Subis hajar to ki dise? Eto. So he is paying 2,40,000 and pocket money when I was staying with him. Then he had all the money. Now after he threw me out of my house, now he is even refusing to pay this amount. And the gentleman has not been paying even if the house rent of 20,000, which was ordered by the court. That will take it in an appropriate application. And even the maintenance which was awarded to be paid from the date of filing of the application, that has also not been paid. Correct?
At this stage, what?
By notice, and your lordship will state this impugn order at page by which our appeal has been
that is your final
or
prayer.
not, sorry.
That is ultimately your final prayer.
No, my lord, but if the maintenance amount is reduced from 25,000 to
That
15.
ultimately, that is saying means that revival of the trial court order, and
Yes.
that is your final prayer also.
Yes, ma'am.
So interim.
No. There are two prayers. One is for enhancement. One is for,
No, this appeal is against which one?
well, against enhance.
See,
Yes.
against your enhancement that has been
Yes.
dismissed.
Your lordship will kindly see my
There
prayer.
has to be,
Yes.
there has to be perhaps
Yes, sir.
four. There should be two.
Your lordship will.
One against dismissal of your.
Since it is a common against both.
No. Procedure.
Your lordship will kindly see my prayer at page 14.
Means First volume.
Yes. Because it was disposed of by a common order.
But common order, but into separate appeal. Procedure is laid down in High Court rules. Cannot be one appeal or revision petition.
Then so far that will get it corrected. But if we treat it for the order by which our maintenance is reduced,
So
Then
as on date, after dismissal of your appeal,
yes, ma'am.
your upper cap is up to the trial court judgment.
Yes,
Upper limit is up to the trial court judgment.
yes,
So the gap is 15,000 and 25,000.
yes, 10,000. Yes, 15,000 and 25,000. That means 10,000 difference.
Appellate court has granted you 15,000 after reduction. And original is trial court judgment 25,000.
25.
So everything is between, since there is no appeal revision
Yes.
against your dismissal order,
Yes. It has been done, but it is done in the same.
No, that is not
application. That they
procedure.
can correct it by filing another short application, and both the matters can be heard together. But today we are on because of the extreme distress condition of the wife and a person who has the ability to pay the capacity. Going out.
it is not an unreasoned order also at the same time.
No, it's unreasoned because looking into the standard of living for which the wife was used to it, considering that 25,000 and 15,000, that is unreasonable when a person is spending 29 lakhs for his own expenses, and we have all his travel
Okay,
documents that he's
okay,
taking
okay.
foreign trips and all.
There are so many other cases. We can put it, if you want to, we have to look into the detail, either to stay, or we can have it immediately after vacation.
Yes,
Or we can put it on notice, but so far as interim prayer also.
Yes.
And we'll decide it finally. It is only interim prayer.
yes. Your lordship can do it immediately after reopening of the vacation.
We can put the respondent on notice. That
Yeah.
is one part.
Yes.
And we'll observe that whatever is the issue on the basis of materials, we'll decide the prayer for interim relief.
Yes.
It will either be set aside
Ah.
or thereafter final relief is in.
It can be disposed of because the domestic violence cases, it will serve no purpose to keep it pending because the statutory mandate is
Right.
6 months,
No,
and
no.
already, they have by staying it in the.
No, had it been this thing without hearing also, this is difficult. And had it been
you
before
can't
had time, we could have fixed it on a hearing date and thereafter
Yeah,
decide.
but today I am also by constraint because it's a motion day.
Motion
Yeah,
date is
your
very
lordship,
difficult.
fix it immediately after reopening of the vacation, and we'll take steps as by normal as well as by dusty post,
Uh-huh.
dusty service.
And hardly 5 days before Bihu.
Yes. Then again up to
19 January.
and 19 I will be just returning back.
Then tell me which is your
on
convenient date.
on 22nd.
22nd is again.
Normal lobi na ki rest.
Okay, you will not be available immediately after Bihu.
19 I am not available. After that I am there, my lord. 22nd will be Thursday, my lord.
22nd.
Because
We
this
put
will
it
be-
on 21st. Thereafter, if required, on 22nd.
Yes.
But Mr. B.D. Kon, Senior Counsel, assisted by Miss as we learned counsel for the petition. First of the petition is aggrieved by an order dated by judgment dated 28/8/2025. Passed by the Court of Additional Session Judge, FTC number 3, Kamrup M. Guwahati Appellate Court in criminal appeal within bracket DV number 13/2025, which arose out of an order dated 27/12/2024, page 691 or so, in Miss within bracket DV case number 8/2024, passed by the Court of Judicial Magistrate first class number 2, Kamrup Metro. Trial court. Full stop. By order dated 27/12/2024, comma, the trial court decided the matter of interim maintenance under section 23 of the Act on Protection of
Protection
the
of
DV Act,
from Domestic Violence
Ah.
Act 2005.
DV Act for short. And by an intra-party order, the trial court observed that in the intra-party order, the trial court observed that the sole respondent,
Yes.
the respondent was already voluntarily paying rupees 10,000 to the petitioner as the aggrieved person for her maintenance. Full stop. The trial court had, does, in addition to the voluntary amount of voluntary contribution of rupees 10,000, or directed to pay a monthly allowance of rupees 15,000 for interim maintenance of the petitioner as aggrieved person by the 10th day of each month, meaning thereby, a total amount of rupees 25,000 as monthly maintenance allowance. Full stop. Agreed by the order dated 27/12/2024, passed by the trial court. The petitioner as well as the respondent preferred to appeals. Full stop. The appeal preferred by the petitioner, criminal appeal number 61/2024, was dismissed by the appellate court on 28/8/2025. Full stop. On the other hand, 61/2024, right?
No, case number to go.
No. This petitioner preferred the appeal on 19 of 2000. On the other hand,
elementary.
the appeal preferred by the respondent herein, criminal appeal DB number 691 of 13 of 2015 was partially allowed by the impugned judgment dated 28/8/2025. Full stop. Para. Mr. Korn, as senior counsel appearing for the petitioner, has submitted that in the assets and liability statement, submitted by the respondent before the trial court, the respondent admitted to have allowed what is this PM2 wife? What is 24,000, 20,000? What is this space?
24,000.
24,000 or 20,000? Two figures are there.
Yearly 2,40,000.
Okay. 20,000 per month to the petitioner. The appellate court without taking into consideration such statement, has arbitrarily reduced the amount to 15,000
Assets and liabilities to both party.
as interim maintenance from rupees 25,000 earlier granted by the Learned Trial Court.
Recorded আছে.
As the issue pertains to interim maintenance, the same requires expeditious consideration and disposal. Post of issue notice returnable on what date you said? 21st. 21st of January 2025. 6. I don't think anything required. Everything is here.
Yes, my lord, only thing is that your lordship may also observe that both the parties have already submitted their assets and liabilities which are part of this record. Just before notice, my lord.
Before expeditious consideration of her right. The statements, what does it say?
The statement of assets and
The
liabilities of both
statements, both the parties
of assets and liabilities.
have already submitted their statements of assets and liabilities before the trial court.
Yes.
Expeditious consideration on the basis of, and the same have been made part of the present criminal revision petition.
But your lordship may call for the TCR from the trial court record. It will be a voluminous.
No,
but-
I think this is interim only. That is why I said. So otherwise, primary case is 20,000 is already set.
Yes.
15,000 granted, trial court granted 25, and as per the statement, 20,000. Issue notice to the purpose of the notice is returnable on is made returnable on 21st of January 2026. লিখি দিব speed post. In addition, Dusty, a compliance affidavit on appearance of the respondent on the returnable date, and an endeavor will be made for disposal of the present criminal revision petition on the issue of interim maintenance.
If they want to file it, any objection, they will file it.
Because the respondent may file its response in the meantime.
Obliged, Your Honor.
Item number 2.
Equal to,
May I please, your lordship?
yes.
Lordship, the revision petition, my lord. But against the concurrent finding.
Yes, Mr. Goswami,
Lordship,
concurrent finding,
concurrent
trial court, let us go to the trial court.
304A.
279 and 304A, lordship.
304A. Where is the conviction and sentence by the trial court?
Lordship, the trial court simple imprisonment for a term of 1 year.
Page.
Lordship, in the post title page 2, my lord.
No, go,
Page
I like to go to,
22.
I
That's
find
right.
many typing mistakes in the
Lordship,
petitions.
in the judgment, my lord.
22 is the, my lord.
Criminal appeal is upheld with.
Page 40, my
jurisdiction.
lord.
Page
Page 40.
40.
Para 18, my lord. Hence, in my opinion, the prosecution has been able to establish the offences against the accused persons. Ziaul Ali under section 279 304A of IPC. Accordingly, the accused person is convicted under so and so.
Heard Mr. P. Das,
Lordship.
learned counsel for the revision petitioner, and Mr. MP Goswami, learned additional public prosecutor for the respondent state. This criminal revision petition is directed against a judgment dated 4/11/2025 passed by the Court of Sessions Judge Baksa Musalpur Appellate Court in Criminal Appeal number 08/2025, whereby the appellate court
Sentence was modified, man, by the appellate court.
partially, whereby the appellate court full stop, dear, full stop. The criminal appeal, the appeal before the appellate court was preferred against a judgment
Dated 10/1/2025.
judgment and order dated 10/1/2025 passed by the Court of Chief Judicial Magistrate Baksa Musalpur Trial Court in PR case number 252/2023. Post of para. The trial court convicted the revision petitioner as accused for the offenses under section 279 IPC and 304 IPC.
304A, my lord.
304A IPC, full stop. For the offense under section 279, IPC, the revision petitioner was sentenced to undergo simple imprisonment of 1 year. And for the offense under section 304A, IPC, he was sentenced to undergo simple imprisonment for 2 years. Full stop. In appeal, the appellate court, while upholding the conviction, modified the sentences in that for the offense under section
For 279, my lord, 3 months. And 1 year.
279 IPC, the revision petitioner has been sentenced to undergo simple imprisonment for 3 months. Full stop. In addition, for the offense under section 304 IPC, the revision petitioner has been sentenced to undergo simple imprisonment for 1 year. Full stop. The sentences are ordered to run concurrently. Full stop. Para. We admit this. The revision petition is admitted for hearing. Issue notice returnable 4 weeks as Mr. Goswami has appeared and accepted notice on additional able for the respondent state issuance of formal notice be dispensed with. So I got admitted for hearing rule, let the TCS from the appellate court as well as from the trial court be called for.
There's an aye, my lord.
4 months. Then I applicant revision petitioner করে দিব, opposite party respondent state করে দিব. Second para to হবো, the instant interlocutory application under section 438. This is equivalent to 389. 438.
389, my lord.
Equivalent to 389.
389 is
ভারতীয় নাগরিক সুরক্ষা সংহিতা 2023 is preferred. seeking suspension of execution of the sentence passed against
438.
the applicant revision petitioner and for his release on bail. So third para. The applicant as the revision petitioner has referred the accompanying criminal revision petition 527/2025. তাৰপিছত সেইখিনি লিখি দিব, trial court লিখি দিব। Para. Yes, any eyewitness?
Lordship, there is a improvement in the version of the witnesses, my lord. In their 161 statement, no witnesses have stated that they were present in the place of occurrence.
Okay.
But
But
subsequently-
did you did you bring the contradiction?
Lordship,
Okay,
it is already proved by the investigating officer, Lord. IO, PW5.
you cross-examine them.
Lordship,
You cross-examine them on
No, my
those
lord.
points?
No,
No.
my lord. Not
Then it
myself,
is
my
not
lord.
then it is not contradiction according to law. Anyway. We have to record some reason, right? It has been submitted that the alleged incident occurred on 30/10/2020. And the FIR was lodged with much delay on 11/1/2021. Full stop. The victim, the alleged victim succumbed to her injuries on 2/1/2021. Full stop. It is further contended that the prosecution witnesses, who in their prosecution witnesses, in their previous statements stated that they did not witness the incident. How many? Two.
Lordship, two witnesses,
Ah.
PW2 and 3.
Two of the prosecution witnesses. But in their testimony before the court, they had improved their version by stating that they witnessed the incident. Full stop. But having regard to the positions made on behalf of the applicant revision petitioner, this court will have considered a view that the applicant petitioner has made out a prima facie case for suspension of the execution of a sentence passed against him and for his release on bail. It is accordingly, it is therefore directed that pending disposal of the accompanying revision petitioner, criminal revision petition, the sentence passed against the applicant revision petitioner shall remain suspended and he is allowed to be released on bail subject to 10,000 on COT to the satisfaction of the trial court.
438 is my lord 397, man. 397 revision, man. Earlier 397 revision, man. 438 1.
390 is some CRPC.
Yes. And in 438 1, there is a provision for granting bail in other, in the
397, I think there is a
provision for bail.
provision for 389, I think.
Yes, provision
Is
for
it not?
389 is my lord 430 now, my.
No, no.
That is in the case of appeal, man.
Appeal, my lord, 418.
No. See.
Kindly see
Uh,
438 1.
no, you see 401
401.
TRPC.
Lord. TRPC. Yes, 40.
There,
High Coast
that
power.
389 is there. That
Yes.
power is there.
Yes,
In revision also.
yes. it is there.
So,
Yeah, it is there, man.
same thing, I think.
Same thing.
Obviously.
I find it very difficult to refer
Lord,
to TNS.
Item 3.
We have to, my lord, remember like earlier days when we used to remember multiplication tables, my lord. In
Yes.
in the morning.
Please, your lordship.
Yes, madam.
My lord, this is my lord,
But
on
clear
against
sir.
the order dated 8/9/2025, page 53.
What is the matter about?
Matter about, my lord, regarding, my lord, on 19/7/2024, my lord,
What is the-
district child protection officer had lodged an FIR that the victim was, my lord, recovered from, my lord, Kisanganj, Bihar. And prior,
Your lordship, you please to admit this petition as to why impugn order,
Yeah.
8/9/2025.
yes,
Already.
Where is that
PCR
page?
PCR already
page
called for,
53,
my
my
lord.
lord.
So, my lord,
Just
can be-
to understand.
it can be-
8/9/2025, where is that?
Page 53, my lord.
Yes, 53. Zapan Hazarika, Zimpi, application personnel are present.
Has been
370, 374, that is trafficking.
trafficking.
So charge was framed.
Charges frame, my lord.
My lord.
Then,
Now, my lord, it was in evidence stage, my lord, on next date, my lord, on 19/12, my lord, this Friday, my lord. My lord, kindly peruse, my lord, victim statement, my lord, page 49.
why this TCR scan copy or
Can copy call for
original copy?
Can go.
scan copy.
Scan copy, yes.
My lord, page 49, my lord, victim statement.
One 183 is equivalent to what? 164.
183 equivalent to 164. And it
Now, what is the FIR first?
Affair, my lord, is page, my lord,
19 lord.
19. My lord, page 20, my lord. Page 20.
Receipt number. Somehow ran away. Shillong then Bihar.
Shillong and
Shillong Meghalaya, Kisanganj Bihar.
Bihar.
Then back to Guwahati or Tinsukia.
Tinsukia, my
Mm.
lord. May I submit, my lord?
I'll submit. Let me understand first.
Yes.
Now, where is the statement you said?
Page 49, my lord.
Juvenile.
Yes.
Juvenile justice.
Section 75.
Nel.
Privacy section 75 is there.
75 is there, my lord.
My lord, what happened, my lord? She reside in our house as a guest, my lord, and she have voluntarily left our house. And that is
So
why,
this is part of the same transaction. You may be, your case may not be, may not attract 370 or 374, but apparently it attracts privacy. Section 75.
yes,
Clear statement.
yes,
Or Jimpy and on.
yes, my lord.
Regarding.
My lord, and when she have left,
So that requires that at the motion stage, it is difficult to
yes, I
set
understand.
aside a part charge sheet.
Lord.
Yes, it may be true that some of the offenses may not be attracted in your case, but from the statement itself,
Yes,
at least 75, section
Seven.
75 is attracted. The word abuse is enough.
my lord, my lord, what happened, my lord, on
And if she is
Minor,
children
minor.
in need of care and protection.
yes, my lord. My lord,
So we'll hear you,
yes, my lord,
not today.
yes, my lord. But when she left our house, my lord, we have immediately lodged an FIR, my lord, that is page 23 to
We'll look into
27.
it. But from the statement
Yes,
itself,
my lord,
75 is there.
Yes.
Some of the
Yes.
other offenses may not be
May not.
there.
yes,
Miss R.S. Deuri, petitioners. So end result is that 370 may not be there, 374 may not be there,
May not be there.
but the other, you'll be tried for that offense.
75.
And Mr. MP Goswami, learned additional public prosecutor for the respondent number 1 state. Who is respondent number 2?
Informant, my lord.
informant, my lord.
Notice
District
served.
Child Protection Office.
Oh, let her come.
Yes,
Let her come.
yes, my lord.
Issue notice
Yes.
returnable on date Radibo.
Page 1.
As Mr. Goswami has appeared for 1, the petitioners shall take steps for service of notice among the respondent number 2 within 3 working days from today. As the scan copies of the TCR have already been received. Let the protection officer come.
Oblige.
Item number 4.
May it please your lordship. This is regarding quashing of a FIR as well as her seat as well as my lord cognizance order, my lord. There are 4 persons here, my lord. The petitioner number 1 is the MLA, my lord. And what happened in this case, my lord? Very interestingly, my lord, there are 2 FIR. There are 2 FIR, my lord. I don't know, my lord, how these 2 FIR both are registered, but same case. And that is, my lord, this situation make it clear.
Let us see.
But I'm not
First
that,
FIR.
not your lordship, kindly see serious law point involved in this case. The person who is my lord victim, he himself is a IO, my lord.
Can be
No,
or
victim,
cannot be. That depends on
the victim, my lord, that man, that we cannot, my lord, fair trial, fair investigation, my lord. Because in that, complainant, my lord, sometime complainant, my lord, there he may be a, my lord, investigation officer in case of NDPS case, my lord, in case.
victim. How victim? First point. What is the FIR? 2 FIR.
My lord, your lordship kindly see Annexa 1. Annexa 1, my lord, that was lodged by Ataur Rahman Law Court.
Page
Page 18, my lord.
photocopy is very.
My lord. That is, my lord,
You
you have to
would
collect
you
it
would not
from my
be
lord.
able to.
Yes,
Whether there are seals and signatures.
and that is difficult, my lord.
In
Then, my lord,
your copy, it is legible.
my copy is also, my lord, same probably. Receive and register, so and so, so and so.
Below it.
Below, my lord,
Below.
Below. What is relevant is below.
below, my lord, that is
Not
not, my
Below,
lord, correct,
yes.
my lord, absolutely correct. That is not right.
right.
And that is probably they collected because since it is a MLA, it is
From
a-
where you have got?
My lord. My lord,
From
that,
where you have got this?
that asks my junior also, they said, my lord,
Because the format.
The format is here in this.
So
case,
it is
my
not
lord,
a certified copy,
that is not a certificate,
apparently.
my lord. There is no
The
format
source
in
of your collection.
collection.
So that goes to,
Implies,
My lord.
goes
No,
for
your
some
lordship kindly
inference.
see,
That goes for some inference
influence.
yeah, next one, your lordship.
on in a matter of influence. If it is not a certified copy, where is the source?
My lord. The source,
You have
my
to
lord,
disclose.
source, my lord, I asked my junior.
As soon as you say the
From social media, it was, my lord, they collected because.
occupation or vocation or what you say,
My lord.
then this is a bit, because source is required.
Yes, my lord. Source is absolutely, source is required, my lord. Your lordship kindly see the annex up to, my lord, that is a ZDNT.
Okay, as I informed over phone that
SIC Deepak Gogoi,
with some other persons jointly took Ataur Rahman Loskar inside the outpost without follow. This is ZD entry.
this is ZDNT, my lord, by Deepak Gogoi. Your lordship kindly
No,
see.
he's a informant
He is the
over
informant.
phone
He is the informant over phone, my
to
lord.
the officer in charge.
That so and so happened and he was
Ah.
stuck.
Okay, that is Deepak Gogoi. Now
Deepak-
let us see the FIR.
Then, my lord, next FIR, my lord.
Ah.
At the page, my lord,
Reference to
25.
subject cited above.
page 25.
Source of one, Taur, Taur Rahman. Yes, then what happened?
Then, my lord, your lordship kindly see here, Deepak Gogoi is the victim, my lord, because 354 is there.
No, that is a hearsay. That
No.
is, sorry, this FIR is lost by Rajan Pao Rongmai.
Now, he is now,
He was the
Victim.
No.
person who informed.
Yes, he is a person.
no, Deepak Gogoi,
CD entry.
Deepak Gogoi also victim also.
No, these are mentioned by the informant. But he did not say in the GD entry.
Your lordship kindly said the FIR, this
I
FIR.
have seen.
In this FIR, he is the 354 is there, my lord. That's why he is the victim. Your lordship kindly see.
No, this FIR has been lodged by the officer in charge.
My lord.
And who has been telephonically informed by the
Deepak
GD
Gogoi.
entry by Deepak Gogoi. At that point of time, it was not recorded that he was assaulted or assaulted.
But here in this is recorded.
It was Ataur Rahman Loskar.
My lord.
He said Deepak Gogoi telephonically informed Ataur Rahman Loskar was assaulted inside the outpost.
Inside the output.
No.
Now, another man lodged the FIR saying that Deepak Gogoi tried to stop and
he's, that's why
did not
354
pay
is,
heed.
354 is there, my lord. 353, my lord. So now, my lord, Deepak Gogoi is the IO here.
Then at what stage? Sarsit.
Stage, my lord,
Sarsit.
yes, Sarsit submitted, my lord.
Let us see the Sarsit.
Sarsit. And before, and another,
Where is Sarsit?
another, I am agreed by the, page 46, my lord.
Page 46. Last part.
And where is the order?
My lord,
Page 65.
65, my lord. What? It start from 62, my lord.
Yes, what do you say about the submission?
My lordship, may kindly see the page 65, my lord. Regarding the ingredients of 307, my lord. Why it has
Oh,
been
that is
placed.
a discussion on 307.
Yes,
The submission of 353.
353, my lord. But now
Ah.
the charges were framed on
What
307.
he is saying,
Yes.
that 307 is a matter of appreciation. It is
No,
not that
no, sir.
one blow or one this thing also, that it is
No, my lord,
attempt to commit murder.
no, actually, my lord, injury report is also not required even my lord 303. Suppose I shoot
Right.
someone, just go near his my lord head.
Yes,
No,
attempt
no
to
injury
murder,
report.
and
But
the
when,
intention is the.
no, but when there is an injury report, you have to go by the injury report. Because there is injury is simple, my lord. Here, that's why that 307 was argued, my lord. Is why there is no ingredient 307 because in the doctor evidence is that the injury is simple. So that's why if it is simple, my lord, you have to go by injury,
We have to also see 20 versus 1
my lord.
inside the police station
Inside Bushman station.
at the same time.
No, sir.
But question is regarding 353, Mr. Mohanto
Yeah.
has asked
Yes.
So that, my lord, there is a whole judgment, but then I will still prevail by 1976.
that the victim cannot be New Vista, New Avenue. Victim cannot be IO.
I owe that, yes. Sir. He is there guarding my lord, your lordship. If we see from the search sheet, my lord.
We don't know, don't have the search sheet in
Uh,
total.
Yes, yes, in total. Then
Because if that is, that may be
because-
a serious point.
because my lord,
Because the trial court, did you urge before it?
My lord, no,
Have you urged that point?
no, that, my lord, only framing of search, my lord. Framing of
Right.
yes.
No, no. Did you urge that point that 353?
My lord, 350 is there, my lord, they have, actually, my lord, this, framed us, yes, search frame under section 353, my
No,
lord.
that I have seen. I have marked also.
My lord,
But did you urge that point that 353 was not?
yes, my lord, page
Because-
63, my lord.
Because I have seen,
Yes, my lord.
because.
Yeah, that was the
I-
point, my lord. Your
uh,
lordship, kindly
no,
page
no,
63, my
because
lord.
Why?
Eyes, my lord. No answer, my lord.
That I don't know, but.
Page
what-
63, last part. Your lordship, kindly see. It was also submitted that the informant, in this case, himself is the investigation officer. In connection regarding the fairness of the
No, that is
investigation.
not correct. Informant is not.
That, my lord,
That wrong.
victim,
That statement is wrong.
victim, my lord.
Victim is the IO. Informant is the investigating officer.
he-
There are laws.
he-
Earlier law has been
Yes,
diluted
correct.
now.
Correct. He, no, although he's
Informant can be investigating officer.
my lord,
That law has been diluted now.
yes, my
diluted, that is-
Right.
diluted.
Right.
But here is the case,
No.
victim has been made IO.
My oh my.
Right.
That point, my lord, decide, my lord. That
That
decide.
is
Yes,
the issue.
that is the issue. That. my lord,
Otherwise, I would not have said informant
No, sir.
is the investigating officer. I would have dismissed it.
No, sir.
It can be.
That judgment I give, my lord. No, but that some cases it is cannot.
No, but
Still, my lord,
where he is not, there is no scope of any element of biasness.
My lord. Yeah, that is true.
Right. This man has been informed, this IO,
My
by the telephonic instruction, he lost the affair.
Yes,
So far, then if he himself investigated,
My lord.
there would have been no issue because he was not there in the outpost. Officer in charge was not there in the outpost.
In that line, judgment is also that
No,
line.
no,
that perhaps
that-
in 1960,
It is not the case that informant is the IO.
my lord.
Here,
Case, my lord, victim is the IO.
that is what I
That
only,
my lord on that.
is only the thing. Otherwise, I would not have looked into it. Yes. Anything say?
my lord, the
Whose statements are recorded?
my lord, statements recorded. Till date, my lord.
No, only my
Whose
lord.
statements in
No,
the
it's-
search sheet, please.
That is also very important, my lord, that how he can record it is himself, my lord.
That is why That is why I am looking into it.
Lordship.
That
Whose
might-
statements recorded during investigation? These are illegible, Mr. Mohanto.
No, my lord, then my lord,
I always look into the original.
original, correct, my lord. Original, sir, my lord, something, yes.
Because in a
Your lordship
translation,
kindly hold a scan copy of-
sometimes non-deliberately
Sometime deliberately.
or otherwise.
That's
I'm
why
not saying
I always, my lord, prefer
no is missing, no missing
no,
of
make
no.
so many difference.
Oh.
So my lord, call for.
Or
the
let us see
scan-
page 46. Rajen Pao Rongmai. Ataur Rahman Loskar, his victim. Saleh Ahmed Borbhuiyan. Rajendra Rajkumar. Iqbal Hussein Loskar. Moinul Haq. But this is IO. Whether IO can be look into it.
Yes.
We'll call for the scan copy, but
my lord.
Complainant now is.
there is a law point,
And
but
yes, sir.
whether that will affect depends upon if his statement is recorded under 161, then it visits. But any police officer here except the informant? Deepak Gogoi is there. He may be the IO.
No, he himself is the victim.
That is what I
That's
know.
why he's been
No, no,
recorded.
I know. His statement is recorded or not. That is what
Recorded, man.
161 recorded.
No, my lord, he never soon as a witness, my lord.
No,
Yes, 46.
IO is always a witness.
I is my lord always a witness.
That my lord-
Always a witness.
Always a witness.
Informant is also a witness.
Yes, always he,
But
he is,
if the IO has recorded his statement, then that goes.
that, my lord,
And these things are very illegible.
Scan copy maybe call for my.
my lord, your
compare-
lordship kindly call for the scan copy, my lord.
Otherwise, my lord. You can.
If take that point,
Yes.
if look at it, if he has recorded his statement, then it goes.
Yes.
My lord.
Complete biasness. But if he has not recorded his statement, then where from 353 comes?
Yes.
And we have to see it holistically, not
Correct.
maybe 353 goes. But if the
That's-
other
Yes.
witnesses,
No, my lord, actually, my point is that my lord, 350 and 307. I think 307 will also go.
that,
Because injury report is very clear, it's simple.
that we have to see the
It's a-
statements.
And my lord, suppose assuming everything is correct, even MLA, he will snatch away 10,000 rupees from the pocket of the my lord in the police station from the victim. That is unbelievable, man.
But otherwise, the issue is very serious.
Exactly, man. That I
cannot
I
be,
agree with you, Lord.
we cannot shut
Yes,
our eyes also.
That type of
At the same time,
movies like
movie-like
30
situation.
and my yes,
Yes, yes, my lord.
that
Hard
is
Mr.
right, my lord.
TJ Mohanty, Lawrence Senior Counsel, assisted by Mr. M.H. Borbhuiyan. N. National Highway. Borbhuiyan for the petitioners and Mr. MP Goswami, Lawrence, additional public prosecutor for the respondent state. Respondent of one state. So stop. The petitioners have assailed the first information report registered as which police station? Ponsgram. Ponsgram.
Pansgam,
Ponsgram
Ponsgram.
Police Station. Case number
59, 2020.
59/2023. Comma, the charge sheet submitted. Charge sheet number 9 second. Charge sheet submitted.
On 31/8/2023.
Charge sheet number?
Charge sheet submitted on page 40.
Charge sheet submitted in that connection on
31. Charge sheet number. Charge sheet number, charge sheet person not yet.
and an order dated
52 case number. Charge sheet number 53 of 2023.
an order dated 14/10/2025 passed by the court of additional session judge, Hailakandi, trial court. In sessions case number 44/2025, post of. By order dated 14/10/2025, charges have been framed against the petitioner for the offenses under sections 367, 143, 148, 448, 323, 353, 357 of the Indian Penal Code, IPC, Redwood section 149 IPC, post of. Para Mr. Mohanto, our senior counsel, appearing for the petitioners, has submitted that from a bare look of the affair as well as and the charge sheet along with the materials annexed thereto would demonstrate that the ingredients of the offenses under section 353 IPC and section 307 IPC were not available. Post of. He has further submitted that as per the affair, one Deepak Gogoi, a sub-inspector of police attached to Ponsgram police station, was allegedly a victim, and yet, he was entrusted with the task of investigation into a case, meaning thereby, the victim himself was the investigating officer of the case, which, according to him, is not permissible in law. So, this is your case.
My lord.
The matter would require consideration. Issue notice returnable immediately. 19-1.
Yes.
19-1. Practice scanned copies of the TCRs he called for. Notice returnable. Steps 1 is Goswami, 2
Yes.
speed post within working day. Prayer for relief will be considered upon perusal of the materials of the legible copies of the
My lord.
TCR.
My lord. And my lord.
Legible
So
copies.
far is my lord,
What is the date of appearance?
next date is my lord, day after tomorrow, my.
Second adjournment.
My lord. No, my lord, so far is my lord, notice on respond number 2 is concerned. I may be allowed to take by hand also, by dusty also.
Whether Dusty is permitted?
Yes, criminal, it is difficult.
Pure
All right.
criminal.
Pure
criminal.
criminal, pure criminal.
Right.
All right, I'll register.
From
One-
DV and maintenance, I have allowed.
Yes.
DV cases have some civil color and plus maintenance 125.
My lord.
But pure criminal, whether it is allowed, then I
There is
can.
no provision, but
Then
that is why your lordship, sorry, I have seen one
In
judgment.
fact, my lord, in criminal notice should be, my lord, in the hand of the male member of the family, not even, my lord, female
Right.
member of the.
Now it is changed.
Now, since, my lord,
BNSS it is changed.
my lord, earlier, my lord.
Male
mem-
is changed now.
Male adult member.
Adult is there, but male is remote.
My lord, the next date, my lord, I'll file no, my lord, day after tomorrow, I'll file a application regarding, my lord, adjournment, my lord.
It is submitted by Mr. Mohanto that next date of in the trial
1912.
is next date of the trial is on 19/1,
1912.
2025. Full stop. The petitioners are at liberty to take appropriate
My lord, deeply.
on that day.
Item 6.
Your lordship, application filed by the informant lordship. Is
Filed by the informant.
lordship, challenging the annexer H and I lordship. So, FIR was lodged lordship. Accordingly, investigation was carried out. Charge sheet was filed against 2 accused persons. Now, lordship, in charge sheet, in page 42, Lordship, relevant paragraph I just refer.
SARS is submitted, yes.
Lordship got 42. That their last paragraph, Lordship.
There might have involvement of others.
Yes, Lordship.
With the assistance of so-and-so and the headship of the so-and-so, the investigation of the case will be continued with a view to collect. So provision for further investigation was
Yes,
there,
Lordship.
okay?
Further investigation was carried out,
Carried out.
Lordship.
Hmm.
In the meantime, on 14/11/2024, a report was submitted by the IO.
1411
14/11, Lordship,
Which page?
page 46, NXRH.
report. The screen colonies and reports are pending from some of the airlines for verification. Final form would be submitted. Yes?
This is
Uh,
stated on the same day, Lordship, NXR I 47 is immediately on the same day, he stated before the court that he has completed and no supplementary charge sheet is to be filed in connection with the investigation of the same.
1411.
Same day, Lordship. And subsequently, the 21/3/2025 order was passed by the learned SDGM 1, Lordship.
Further investigation may not unearth incriminating materials.
No, Lordship.
The question is, it is the prerogative of the IO.
Lordship.
He can carry out further investigation under section 173C
Lordship.
after filing of the charge sheet.
Lordship.
Then, after further investigation,
Lordship.
he was looking into some thing from airlines.
Lordship.
Then, after his further investigation, he may think that it is not a case for filing of supplementary charge sheet.
Lordship.
Right. So he said, no supplementary charge sheet is to be filed.
No, Lordship. On the same day, 2 reports have come, Lordship.
Oh, that nothing is.
No, Lordship.
So
Some, Lordship, we have supplied our report also, Lordship.
that
So
is
many
a different
persons have-
matter. We'll call for
Lordship.
the scan copy and case diary.
Lordship.
Right.
Lordship.
Nothing more than that can be done at this
Lordship.
stage. Heard Mr.
Hello.
A.K. Dotto, learned counsel for the petitioner, and Mr. M.P. Goswami, learned additional public prosecutor. Respond number 1, State of Assam. Who are these? 2 and 3.
2 and 3, Lordship, accused. Two accused persons already they are in
Sent
trial.
up for
court.
trial.
I think
They
they
are
are not.
And
The
also-
petitioner
Right.
has contended that after submission of charge sheet, a charge sheet, in connection with Potasil Ambari Police Station case number 817/2021, further investigation was carried out, and it was on 14/11/2024.
Lordship.
Oh, sorry, on 29/8/2024, the trial court called for a report from the investigating officer on the status of further investigation, or if any supplementary charge sheet would be filed as a result of such investigation, full stop, on 14/11/2024, the IO had, at first, reported that the further investigation was on and some reports were awaited from airlines for verification. Full stop. But on 14/11/2024, the IO once again submitted a status report before the trial court stating that further investigation was complete and no supplementary charge sheet was to be filed. Full stop. The petitioner has the safe hit has also again been recorded by the trial court on 21/3/2025. Full stop. Agreed thereby. The petition is before this court. Issue notice returnable on so and so.
3001.
Mr. Goswami 1,
Yes.
2 and 3 by speed post. Tar agote likhibo. The scanned copies of PRC 1881 2022 and the case diary of Potasil Ambari Police Station so and so be called for.
On before 30. It was 30. On 3-2 lordship, that trial court
Not
matter is
30. January last year.
obliged.
Yes.
My lord, this is in petition challenging the recall of the accused, all the accused. All the witnesses, all the witness PW 1 to 4, which is at page 48, annexure H.
What is the petition?
The-
Custody.
Criminal.
Where is the charge sheet?
Charge sheet at
Charge sheet
page
under
11,
section,
and it's
section
A.
10,
Page 11.
inappropriate touch. And application for recalling is at page 33. Your lordship will find the justification from paragraph number 8.
Deemed charge. Tested chapter profile submitted charge sheet. And calculate frame charge 74 PNS. Proceeded statements were recorded to the minor proceedings were conducted. They have to be examined. Region equation. So there was change of counsel.
Yes,
A
ma'am.
change of counsel is one thing, but this contradiction, yes,
In 311, it is material.
yes, no, but your lordship, so far this 311 application is justification for recall of the witness.
We'll
is-
see to that.
Yes,
But one factor is change of counsel.
yes,
Okay. Now, where are the justifications?
at page 37. Only the contradictions were not put to the witness, which is a statutory right, as your lordship knows, that under the contradiction has to be put in terms of section 145 of the
Right.
evidence.
It is a right.
Yes, madam.
But question is, after examination of all the witnesses,
Recall is justified if I can give the justification.
that it has to meet higher threshold. Where is the region?
At page 37,
No region.
No,
Page
no.
49.
no, yeah,
Because it has to, the court has to record regions.
yes,
Where is the region?
means regions in the impugn order.
Yes.
That your lordship will see first my application. I will not comment on the order of the learned judge because.
Because it has
Correct.
to
Well,
meet a
now-
higher threshold.
Yes. Now also, since both the parties are there, your lordship can hear on the merits of the application. Your lordship will see page 37, my justification for first witness PW1, because these are the witnesses which I can't influence. Even if they are recalled for this limited purpose, no prejudice will be caused to them. Your lordship will kindly see page 37, justification for recall of PW1. The contradiction, my lord, which was not put is at page 38. Because unless the why contradiction is necessary? Because to test the credibility of the witness at any stage before pronouncement of the judgment.
Right, but it is also a settled position that cannot be recalled to fill up the lacuna.
This is not a case of filling up the lacuna if the contradictions are not put, because this is a procedural lapse and there are judgments of the Honorable Supreme Court which said.
So
Yes. First, your lordship will see my application. Your lordship will kindly see. Let my learned friend, otherwise it will. If he has anything to say, others I will not.
Please.
This is my junior brother, my lord. Let him.
Please.
My lord.
Let us see page 37.
Yes, ma'am. Page 37, ma'am.
Yes, let him say.
Yes.
The only thing is that I'm 8.1, the portion being material and improvement and omission on their part. And in the order,
During examination, PW1, several material assertions were introduced for the first time. In court, we do not find place in his statement. Therefore, being material improvement and omission are required to be put to the accused and duly comes not be done earlier. For being fiction.
This statement which shows that below from 2 to 8, this was never made in the 161 statement. And now this is 148 is the earlier 145 of the Evidence Act.
On a very day,
This all three witnesses are, my lord, the victim, the parents, where I cannot influence any of them. Only these contradictions has to be put to them.
show us the law.
Yes.
That put
Yes,
for
yes,
contradiction.
yes. But
That
I'll be happy.
failure on the part of the earlier engaged counsel.
No, not only earlier.
No. Change of advocate is very important.
Yes, but will show.
Show us.
Yes.
On 2 points.
My lord, first,
2 points.
yes.
You show.
Yes.
First, after change of counsel, the later counsel has more wisdom.
No.
No. This is one very pertinent point.
Yes. I'll address to it.
And second,
yeah.
that just because contradictions were not proved,
Good. That will cause prejudice.
yes.
Yes. But first,
On the 2
yes,
points.
I'll
On
address here.
change of counsel.
First, let me go on my way. The change of counsel, I'll come second. First, let me address the statutory importance of putting up the contradictions. Why contradictions are necessary. That for that, your lordship will kindly. The first decision, my lord, your lordship is aware, the Tahsildar Singh's case. So Tahsildars I need not place before your lordship because
That is a procedure.
it's a procedure. And it is
How
a
to prove contradiction
Yes.
or omission?
Yes.
Omission by diction,
Yes.
contradiction.
So that if contradiction is not put to the witness in the procedure prescribed under section 145 of the Indian Evidence Act.
Mr.
earlier-
Kaur,
Yes.
in hundreds of trials,
Yes, madam.
we have seen out of 100 in 95.
Yes.
95.
Yes.
It is not by way of procedure as laid down in Tahsildar Singh.
Yes. Now what has happened?
Only in
Now,
few
yes.
cases where Mr.
Yes.
Kaur is appearing or other councillor.
No. Madam, why?
They
Now,
put
that's
the
why.
contradiction
Madam, that's why.
regard to 161.
Yes. Madam, with utmost respect, that's why the Honorable Supreme Court has said that if a junior counsel, say, appears in a case and he doesn't know the law, how to put the contradiction to the witness, the court cannot remain a mute spectator. The
That is
court-
also there.
the court has to guide the junior counsel that you see.
No, that
this
is not there.
Not,
Court has to put the question himself. What, section 165?
yes.
Not that guide. I have not come across it.
I'll show it. I'll show it.
That guide,
yeah.
please ask this question.
No.
No.
Court will not remain a mute spectator.
That is 165.
Yes.
Court can
Yes.
ask question.
Yes. No, court can ask question to elicit the truth.
Extract the truth.
But we'll go step by step. First, your lordship will.
Don't say that,
yes.
that court will guide. Please
Yes.
ask this
Yes,
question,
we'll
bring
go-
that
no.
161
how the law
statement.
has, yes, madam. How the law has evolved, let me go madam, step by step. In Tahsildar's case, madam, your lordship is aware that the contradiction has to be put in terms of section 145. Contradiction means the statement which was not made before the police was made before for the first time in the court, or it was not made before the police, then now in the court it is given a completely new version. That was the
Before going into all those aspects,
yes, madam.
primacy, the impugn order
Yes, madam.
is not to the full satisfaction of the court.
No, that's why your lordship can hear us on as then justify
Right.
whether the contradiction
That
is required or
whether
not.
Today is the conducive time to hear all this, because this can be disposed of.
No, person is in custody, my lord. Person is
Whether you are available on 5th or so, because the holiday is hanging, other councils are there.
so, my lord, so far,
Or after the motion, we can hear.
my lord, what is there? Because the person is in custody
That I
and
know.
he is appearing only for the 3 witnesses. The 4th one witness which has been recalled is not appearing. Our only contention is that your lordship will just take one judgment whether this is a statutory right can be done under re-examination or not.
That can be done.
Are you given motion? Say that.
There is no
My lord, we'll
doubt to
try-
the
Yes,
proposition,
my lord.
but the question is the trial court
Yeah.
to arrive that yes, for these reasons, these are required to be recalled. For that, the trial court has to meet, the order of the trial court has to meet a higher threshold.
Yes.
Which to the
My lord, say.
understanding of the court
My lord,
is not there.
My lord,
Your petition is exhaustive.
yes, my lord, because we'll not take chance. Because we have to,
Right.
because this petition is drafted on the guidelines
Right,
of
but
the
page
Honorable
49
Supreme Court.
Page 49, I have understood.
Yes. Because unless I,
Page 49, first paragraph.
yes.
First page 49, first paragraph.
Petition content. Just a moment.
There appears to be no reason.
My lord, why I tell your lordship? My lord, your lordship will see. The learned POXO judge has not quoted from my petition to justify why this contradiction is required to be proved or not. But the order your lordship will find, the learned defense counsel in the petition number 18575 clearly stated the points on which the defense side intends to further cross-examination PW1, PW3 and PW4 and requested that a prayer may be allowed for just decision in this case.
This is not a
Learned counsel
judicial
also,
decision. This is not a judicial order.
then your
petition is correct.
Yes.
I'm not doubting about your petition.
ultimately, at the end of the day, your lordship has to only decide whether this contradiction is required to be put or not. And if this contradiction is not allowed to be put by the accused,
What
whether
happened?
this can
On
be considered.
5/12/2025, what happened?
Madam?
On 5/12/2025, what happened?
They filed an application before the judge that they have moved
When is the next date?
today.
Today itself.
Today. That's why the court has fixed it today, because any outcome of this order will affect the further proceeding of that case.
So what's your law?
Yes, ma'am. Yes.
Change of counsel?
No, not from change of counsel. We'll go step by step, my lord. Your lordship will first see.
I paid today.
No, I have extra copy also, my lord. First today. Allowed into lawyer. First, your lordship will kindly see the law on recall of 311, my lord. From there, we'll go first. Your lordship will first look into the judgment, extra copy to DB. 2006 3 SCC, page 374. 2006 3 SCC 374. Jahira Habibullah Sheikh versus State of Gujarat, madam. 2006 3 SCC 374. Your Lordship, kindly see, Your Lordship got the judgment? Your Lordship will first see, it starts from paragraph number 26. In paragraph number 26, it discusses section 311 of the old CRPC, which is now 340, 348 of the BNSS. Now, so far as paragraph 26 is concerned, it discussed 311 that it consists of two parts. And 27, the first three lines is very important. The object underlying section 311 of the code is that there may not be failure of justice on account of mistake of either party in bringing the valuable evidence on record or leaving ambiguity in the statements of the witness examined from either side. The determining factor is whether it is essential to the just decision of the case. This section is not limited only for the benefit of the accused, and it will not be an improper exercise of the powers of the court. Then it discusses section 311.
Yes, to bring contradiction.
Yes. So if there is a failure on the part of the counsel to bring on record, the court will be
First, two aspects. I am asking for two aspects only.
Yes, sir.
Please, 311, just decision. I know nobody,
Yes.
should be a fair trial.
Yes.
Two on two aspects. First, three rather. First is change of counsel. Second is because of the failure to bring contradiction or to establish embellishment or improvement.
Yes.
Right?
Yes.
311 can be used or not.
Yes.
That is the only
Yeah,
issue.
yes. Malat, if you
That is the
only
only issue.
see,
For
if you-
me.
yes, if you only say that because of change of counsel,
No.
only if you cannot justify that the why the change of counsel, or if you only say that just because the change of counsel some questions were not put,
No.
then you cannot invoke that
No,
power.
first one is the second aspect first then.
Yes.
That to prove contradiction or to establish embellishment
Yes.
or improvement
Yes.
in the version of the
Prosecution witnesses.
prosecution witnesses qua their previous statements.
Yes.
Right?
Yes.
So any 311 can be used for that.
Yes,
Any law directly.
But first, you have seen, your Lordship has seen paragraph number 27. It says that there may not be failure of justice on account of mistake of either party in bringing the valuable evidence on record. Why this evidence is necessary? Because to test the credibility of the witness. That is the whole purpose behind 145 of the.
Do you have any decision? Do you have any decision on
Yes,
the
sir,
aspect
your
which I have just asked?
Yes, your Lordship will see. Now your Lordship will see the next decision. Next decision is my lord 2007 11 SCC 211. I'll go step by step. Iddar today. Iddar versus Abhidaf. It starts from my lord, from paragraph number 9. If that is judgment to hold 2007 11 SCC 211. Sometimes it is difficult to pick up a word by word from a judgment and show to this honorable court, but I will try to show that under 311, if some mistakes or errors have kept or that can be corrected. Contradiction eta direct judgment eta asil no? Contradiction. Ini buat ase. Itu allowed in a contradiction put. Under pressure to kill. Walaupun bisa tahu. Itu lihat today. Itu lihat. Di Sanjeev Rao.
Yes.
Then your lordship will find the next judgment is P. Sanjeeva Rao versus State of Andhra Pradesh, which quoted the judgment of Rajendra Pradas. Your lordship will look at 2012 7 SCC page 56. It does. It starts from paragraph number 7. The first paragraph, it starts from 7. Because if your lordship doesn't look at paragraph number 7, the other point can't be appreciated. Paragraph number 7. Heavy reliance was placed by the learned counsel on the decision of this court in Rajendra Prasad
Number
7. And this
Sanjeeva Rao.
Sanjeeva Rao.
Ramanujan.
Your lordship will omit those 5 lines. Then your lordship will see what was the submission. Heavy reliance was placed by the learned counsel on the decision of this court in Rajendra Prasad versus Narcotics Cell. I'll come to the decision next, my lord. In support of this submission that no party to a trial can be denied the opportunity to correct errors, if any, committed by it.
No, read from the first line itself.
Mr. Ramanujam asks that while the lawyer may have committed a mistake in presuming that prosecution number, witness number 1 and 2 could be recalled for cross-examination at a later stage, without the trial court granting to the accused the liberty to do so, such a mistake should not vitiate the trial by denying the appellant a fair opportunity to cross-examine the said witness. Heavy reliance was placed by the learned counsel on the decision of this court in Rajendra Prasad versus Narcotics Cell in support of his submission that no party to a trial can be denied the opportunity to correct errors, if any, committed by it. If proper evidence was not adduced or the relevant material was not brought on record due to any inadvertence, the court should be magnanimous in permitting such a mistake to be rectified. Now your lordship will go to paragraph number 14.
1 minute. 1 minute.
Then your lordship will go to 14. Your lordship may omit. Your lordship will go to paragraph number 17. Your lordship got paragraph number 17. We are therefore inclined to believe that the 2 prosecution witnesses were not cross-examined by the counsel for the appellant, not because there was nothing incriminating in their testimony against the appellant, but because the counsel for the appellant had indeed intended to cross-examine them after the trap-laying officer had been examined.
That is different.
Your lordship will see the observation at bottom line. But merely because a mistake was committed should not result in the accused suffering a penalty totally disproportionate to the gravity of the error committed by his lawyer.
This is the fact that those 2 witnesses were not examined at all.
Here also,
cross-examined at all.
Here also your lordship will see.
They were examined here. Cross-examined.
But the contradiction was not put to them.
Right.
Now your lordship will see. If the witnesses are recalled and if the contradictions are put to them, how they will prejudice? I cannot prejudice. I have to only simply put the question whether this was put to you during
Don't the exact law.
Exact law, word by word, your lordship has to interpret the law. Exact law, we may not get it in the judgment.
This must be available. That's to the witnesses were cross-examined by the defense at an earlier point of time. And subsequently, some questions were not put for purpose of contradiction or to establish embellishment or improvement. So those witnesses can be recalled.
My lord,
This is very simple.
my lord, your lordship will not find a direct judgment on this point.
Perhaps
Your lordship
given
has
2
to
days time,
interpret-
I'll be able to do it.
My lord,
Given 2 days time, 3 days time, I may not have this resources right now. Perhaps Mr. Kaur will be able to place it.
no, my lord, I have seen, my lord, so far 311 is concessed. The court is always magnanimous. My lord, if suppose, my lord, what will happen? Suppose your lordship doesn't allow this witness to allow the contradiction to be put to the recalled witnesses, then what will be the
Okay,
consequences?
we'll
Then-
hear it again
then-
tomorrow.
Tomorrow. My lord, not
Okay.
before. not-
Yesterday also I got it. Then 2 cases were heard. By evening I got the result. Now they have, I pointed out. But today I come with the judgments, but both of the petitions were withdrawn in the morning itself. So I'll find
No,
out.
my lord, then
Tomorrow?
Then we'll have it after vacation, immediately after reopening of the vacation. Since they have not summoned, so witnesses were not summoned, your lordship will not stay the proceeding because I assured that immediately after vacation we'll hear the matter and they can wait till then. But the IO, my lord, there is no stay order in regard to the IO and all because
I
he is
know,
not-
IO is a different issue.
and
IO
but-
is a
but-
different
no,
issue.
my
Or a
anxiety,
POCSO case,
No, my lord,
there are other issues also.
my lord, my
that
anxiety is only. my lord,
Victims' parents
Yes.
were to be recalled.
yes.
These are also issues which have not been dealt by Supreme Court.
No, no, my lord, so far, my
So
lord,
far a POCSO case is concerned.
no, my lord, so far POCSO cases are concerned, in the act.
Many
it-
factors.
No, my lord, in the act itself, it is said that it is not to be recalled again and again or after and after. But for re-examination in that section, it is said that if it is for the ends of justice, today if this contradictions are not put to the witness, if it is very antithesis to the fair trial that is to be given to the accused.
We'll see to that if tomorrow or otherwise after vacation.
After
should.
vacation only, my lord, on 5th.
My lord, there is an interim there also.
What interim?
Because
No,
we-
no.
There's
You
supplementary.
seek an adjournment.
And
No,
last time also when they shot adjournment, there was no interim order. The court granted that since the matter is now pending, you
Ah.
don't need an interim order for that.
Heard Mr.
S. Singh. S. Singh.
Learned Counsel for the petitioner. And it is a state trial.
Yes.
Do you have a locus to object otherwise? You're a witness
I-
or you are agreed person.
In this particular,
My informant and the mothers, that's why we will not go
We'll
into
not
that.
also,
We
we'll not
want
go into
law
that.
to be
We'll
settled
not go
for
into
one.
that. And Mr. B.D. Kaur, learned senior counsel, assisted by Mr. has entered appearance on behalf of the
Respondent
respondent
number
number 2. Also heard Ms. A. Begum, learned additional public prosecutor for the respondent said, yes, what do you say? Your submission is material because before the trial court, the PP conceded.
You are seeing my application.
I don't know. What is the point, law point? Law. Settled proposition.
But
Are you ready with? Okay.
but
As
it-
sought for by the part,
but-
counsel for the parties, list the case on 5-1.
to প্রথম খুলিব নেকি না?
I think Mr. Singh or
Let
Mr.
it be on
Kaur,
7. 7.
Singh and Mr. Kaur would be able to find out.
No, my lord, I have seen, my lord, this type of question of putting the contradiction cannot be considered as a lacuna. That judgment I have. Because filling up of the lacuna concept is more with the prosecution than with the accused because this type of omission or due to the mistake or the error of the lawyer, the accused should not suffer. And that's why 311 has
If
been
I
given.
sit on 7th in this bench, I'll come prepared.
If it is there before this bench.
Yes.
Ah.
Item 10,
you can take back the judgments
Yes, yes.
because I may not,
Yes. Like,
it will be wastage of paper.
yes. Nowadays, everything is online also.
Good to hear you.
Obliged.
Issue is important.
Lordship, petitioner before your lordship
Yes,
praying
sir.
for recall and the NBWA issued by the learned edition session just Sri Bhumi against the petitioner, my lord. Petitioner was arrested.
Yes,
pursuant
Mr.
to
Azad,
granted
take me
bail.
to the first FIR.
My lord.
FIR,
NDPS Lordship,
NDPS.
Lordship.
My lord, lordship filed case
NDPS
20,
FIR 2021.
my lord. Case is appearance stage, my lord. I am appearing, but
21C29. Then search it
charge sheet, my lord, page
when
19. And example 2.
search it 21. You are Mr.
Amiruddin,
Petitioner.
Amiruddin, my lord.
Amiruddin.
Amiruddin.
Drug from possession of below noted accused persons. Okay. Then
Lordship will find case
after receipt of process
my lord,
summons,
my lord,
you received?
my lord, my lord,
Did you appear?
my lord.
Did you appear?
Yes, yes. I
Well,
have appeared, my
let us see.
Page number.
page, lordship will find page 27, my lord,
Huh.
And
Absent
exactly.
with steps.
my lord.
Have you gone on bail?
Bail,
Have you gone on bail?
my lord.
When?
Bail, my lord, 27/7/2021, my lord,
27/7/2021.
my lord.
The order is available.
Order is, I have not annexed, my lord, but I have given
Have you
statement,
stated?
my lord. There are 6, my lord, I have stated.
There are 6.
After filing charge sheet,
Granted bail.
granted bail, my lord.
Okay. Then what happened? 2022, 23. Did you appear personally thereafter?
No, my lord. My
Huh?
advocate,
Good.
filed a
Not
petition, my lord.
So why you are not appearing?
No,
Every
lordship-
time absent with steps.
My lord.
Hmm?
Lordship will find page 29, my lord.
Then page 30,
Yes,
absent without steps.
my lord.
BWA.
My lord. This is the first order, my lord.
Then next order, BWA. Then BWA from February 2024.
NBW issue, my lord, on 22/2025. my
Huh.
lord.
Page number.
February
Page number
2024.
39, 33, my lord.
No. Page 30, February 6th,
My lord,
2022,
my lord,
without steps.
my lord.
Then up to
August. Appearance.
February 2025. February 2025,
My lord,
page 33.
33, my lord.
BWA issued against the accused return answer with report that accused went outside. It seems that accused is avoiding process, hence issue NBWA.
NBW, my lord,
So it is about 2 years.
my lord.
Why should we
My lord,
exercise our power?
my mother was ill, my lord. Subsequently, my mother died, my lord. Did I have
When your mother died?
My lord, I have annexed a death certificate of my mother, my lord.
That is in August. But previous to that,
Page 38, my lord.
I've seen on 29 August 2025.
My lord. My lord, I will appear, my lord. Till then, my warrant may be suspended, my lord. I will face trial, my
Yes,
lord.
madam.
I will face trial, my lord.
Who are the others?
Any condition, my lord.
How
I will-
many? How many?
One petitioner, Lord.
One petition, my lord.
Amiruddin.
Other, they are appearing, my lord.
Okay, 10.
Very bad conduct.
Yes, my lord. That's right. This way, come before your lordship. I will appear.
Let it stand.
You appear. Heard Mr. A.K. Azad, learned counsel for the petitioner, and Ms. A. Begum, learned additional public prosecutor for the respondent state. So, the first information was lodged on 23/1/2021. before the officer in charge. Which police station?
Bazari sir,
Bajari Sira Police Station. As regards seizure of suspected contraband from the possession of a number of accused persons, including the petitioner. Full stop. The FIR was registered as Bajari Sera Police Station, case number 17/2021 for the offenses under section 21 within bracket small c /29, NDPS Act. And the accused was accused petitioner was arrested. Full stop. After investigation, a charge sheet was submitted under section 173C 2C CRPC, right, charge sheet number 80/2021. Full stop. Where the petitioner has stated that after receipt of summons from the court of from the special court,
my lord. Additional.
special Court of Learned Additional Session Judge, FTC, Sribhumi, within bracket special court. The petitioner appeared before the special court and submitted an application for releasing him on bail. Post of on 27/7/2021, the special court allowed the accused petitioner to go on bail. Post of para on and from from the order sheets, annexed to the instant criminal petition, it transpires that on and from 1/12/2022, the accused petitioner was absent with steps before the special court. Full stop. On and from 6/2/2024. The accused petitioner was absent without steps before the trial court, and the trial court, special court, and the trial court had to issue bailable warrant of arrest against the accused petitioner to secure his appearance in the trial. Full stop. When on 22/2025, the special court received a report that the accused petitioner had gone outside, the special court formed an opinion that the accused petitioner was avoiding process of the court and ordered for issuance of non-bailable warrant of arrest against the accused petitioner. Full stop. On the subsequent dates also, the accused petitioner was found absent without steps, and the special court ordered for issuance of non-bailable warrant of NBWA against the accused petitioner. Full stop. Para. From the order sheets, it transpires that the other accused persons, 3 of the other accused, suspected accused persons used to appear physically, had appeared physically on many occasions. Full stop. Para. The above conduct of the petitioner have demonstrated the conduct, the with his continuous absence before the special court since 1/12/2022. The petitioner has exhibited bad conduct. Full stop. Para. This petition, in this petition, the petitioner has sought to explain his absence by stating that his mother had expired in the meantime. Full stop. From the death certificate annexed to this criminal petition, it is noticed that the mother of the accused petitioner expired only on 29/8/2025. Full stop. There was no reasonable explanation from the petitioner as regards his absence on and from 1/12/2022. Full stop. Be that as it may. Full stop. As the other charged accused persons are have been appearing in the trial, and the petitioner's continued absence appears to be a hindrance in facilitating an expeditious conclusion of the trial, this court is of the considered view. The petitioner has submitted that there would be no default on the part of the petitioner henceforth, and he would appear regularly without any default in the trial before the special court. This court is of the considered view that for in the interest of expeditious conclusion of trial, the non-bailable warrant of arrest issued against the petitioner can be kept in abeyance till the next date of the trial, that is
3rd January 26.
3rd January 2026. In order to so that the accused petitioner can appear on the next date of trial without the threat of being arrested till then. Full stop. It is the petitioner shall appear on 3/1/2026 before the special court. Full stop. Order. It is ordered accordingly with the observation. Stop. It is further observed that in the event the petitioner appears before the special court on 3/1/2026 and submits an application seeking his release on bail, either on previous bail or on fresh bail, the special court shall consider such application in accord on its own merits and in accordance with law.
Item 11.
This order disposes of the criminal petition.
Wait, please, your lordship.
Yes.
My lord, this is for quashing of the proceeding of PRC case number, my lord, 134/25.
What is the FIR or complaint?
My lord, earlier, my lord, there was a FIR, my lord. You have approached this honorable court, my lord, filing a criminal petition, my lord.
Tunmoni Dotto Sanjoy Bora. Yes.
During pendency of that case, my lord, meantime charge sheet has been submitted and also someone was issued to. So
someone issued.
Yes, my lord.
Then you can hesitate that no charge is framed or can be framed.
Charge has not been framed. This petitioner has not
That
been.
materials are deficient to frame any charge against you for the offense under what? 420 or what?
Yes, my lord, the offense
420.
charge is under 384, my lord. Finally, my lord.
384.
Yes, my lord. But
Extortion.
Extortion, my lord. But I have taken the law point, my lord, earlier also, my lord, and this petition also, my lord, because, my lord, mandatory provision of section 202, earlier CRPC, my lord, has not been followed. Because, my lord, Apparently, my lord, these petitioners are the residents of the Guwahati, my lord, Kamrup district.
First, you take me to the events first. What happened
Lordship,
first?
Lordship, may I kindly see, my lord, complaint.
For my learned senior submitted my senior colleague, may one thing, my lord, may I like to point it out, my lord. My lord, before this, my lord, petition, my lord, another, my lord, criminal petition, my lord, which is filed before this honorable court, and that is pending, my lord. Only,
Yes.
that is, my lord, the para 3, they have stated, my lord. And that matter is still pending before the court, my honorable court, my lord. Only the difference is that, my lord, in that, my lord, para 3, my
Para
lord,
3.
para 3, my lord, page 5, my lord.
Propose this court because challenging legality and validity registration of FIR, York Police Station, 145, dated so and so, on 3 counts. From the face of the complaint, it concerns the allegation on 420 doesn't appear. 202 is a resident and impugn other Austin so and so. Then 3 grounds you have taken. Now you again hesitating 202. That is under consideration in the other criminal petition.
So,
According
that
to
is-
your own statement.
After filing
And
of
that
the charge
petition
sheet,
is, my lord, pending, my lord.
But
And
not
on the face
dispose
of
of
the
mine.
complaint, offense under section 42406, 383 are not made out. That is also hesitated in the other petition.
yes, man. That is I
Then
prayed for-
thirdly,
I prayed
that
for-
order of that 156.3, then ultimately it has resulted into charge sheet.
charge
You
sheet.
bring it in that petition. Why
Yes, my lord.
second phase petition?
My lord, because earlier was no question of the FIR. my lord.
Earlier you did not get any interim order.
Yes,
my lord.
But,
That-
the-
That is the only reason.
There
And
is, no,
respondent
no, my lord,
appeared
there
there.
is observation, my lord, after, my lord, appearance of the respondent.
You hesitate.
So that is pending, my lord, but
The law
subsequently.
is also settled if the FIR is, do not make out.
So my prayer is, my lord, this petition may be taken.
No, this petition I am dismissing you.
Yes,
cost.
my lord.
Because, my lord,
Cost.
subsequently charge sheet has been submitted, my lord. Earlier not charge sheet was submitted.
Yes. Then also the law is also
Yes.
settled. Is
Yes.
it not?
Yes, my lord.
But, my lord,
During the pendency of the criminal
Yes,
petition,
tendency
No,
of the
my-
petition,
if the charge sheet is submitted,
my lord.
still it can be considered.
Yes, my lord. And
My lord.
there is no stay, my lord, in
My-
that, my lord.
my lord,
In earlier, my lord, it is, my lord, the
Yes,
last
you
order,
have hesitated.
2425,
my
my
lord,
lord.
I have not, my lord,
Page 4.
suppressed, my lord, any fact, my lord.
Right.
Yes, my lord. My lord, I have gone through some decision by filing additional affidavit or like this, my lord, it will not, my lord, cover the subsequent, my lord, because there is a new cause of action when charge sheet has been submitted. So either I have to withdraw that petition.
That you withdraw.
My lord. So my prayer,
Otherwise, that you withdraw.
I will withdraw that petition and that petition,
At least this case,
along with that petition, my lord. Today I made statement.
then you make a withdrawal. You cannot go for two-pronged attack.
No, my lord. That's why I made prayer, my lord, to, my lord, take the matter with.
Okay, on the prayer of Mr. Ziuddin, Learned Counsel for the petitioner, raised the case on 7/1/2026 along with criminal petition number
My lord, 1272, my lord, I have some taken, my lord. 72/2020.
Mr.
K. Boysa, my lord.
A. Boyshal and additional public prosecutor is present.
Item 12.
May it please the lordship.
Hmm.
All right.
This is the first date. We have received the copy. I need to file reply. Detail.
Whatever is there.
Otherwise, lordship, my prayer was that if stay could be granted, because otherwise if.
That come to page 36.
Lordship. Lordship.
After all these marks, 5 marks, then
Lordship.
second, the bullet points. After that, 2 lines. Then first bullet point. During the period from 2019 to 2022.
20.
Now you come to page 38.
38, lordship.
Why should we entertain?
No, lordship, because.
We're not entertaining it.
Lordship, because the wife In fact, there's an inbuilt protective provision for exactly situations like this. If your lordship will kindly see 27.
Read page, pair 30.
Lordship.
Page
30
38.
Page 38.
I read first
the
paragraph.
Entire first paragraph.
First, yes, fully.
It is established that current account number so and so in the name of Kiran Physiotherapy Clinic, Jorhat, is being maintained with Canara Bank so and so, wherein crime proceeds. Defrauded amount were transferred, credited from ONGC Jorhat. The same has been scrutinized, which revealed that on 23/5/2019, an amount of rupees 3 lakh was transferred to the account of in the name of Srimati Basabi Datta Shaw, who happens to be the petitioner, wife of accused Dr. Bijoy Kumar Shaw, maintained in Axis Bank so and so so and so. Yes, and through NEFT, which proved that accused Bijoy Kumar Shaw has taken undue advantage from accused Jadumani Hazarika in lieu of the numerous fake requisition slips issued in the name of retired beneficiaries. So, Lordship, so far as Dr. Bijoy Shaw, accused number 1, 2, 3.
Your husband?
Yes, my husband.
He was fully suspected.
Rightfully.
Right? Then this man, he was in conspiracy with this man, Jadumani Hazarika.
Lordship.
That is the case.
Lordship,
Case about.
I'm not.
And that man, that man transferred it amount of rupees 3 lakh in your account as far back as on 23/5/2019.
Lordship.
And you are sitting over it. You are sitting over that money.
No, Lordship. So,
You returned it.
no, I did not return it. So,
then-
Lordship, but first it is their job to at least establish
This is
that
a matter of appreciation, sir.
Lordship, I agree, Lordship.
And we are not will not appreciate this kind of evidence to be brought into the court.
Lordship. But Lordship, if Lordship may kindly see
this
section
court has the
57.
power to dismiss in the motion stage itself.
Prima facie case is there. There is a transaction between.
This is a matter of
husband and
appreciation.
Both of them are. the-
Lordship, I'm not disputing that also. Even if we assume in toto that whatever the allegations is leveled is true, Lordship, what is Lordship wife's instigation or complicity in this? She has received it. Okay. Even I am not denying that for the
This is
sake
a
of argument.
mental thing which is to be proved. This instigation, part of the conspiracy. Conspiracy is a thing,
I mean,
120B, which cannot, where direct evidence cannot be laid.
Lordship.
It is to be inferred from the evidence
And circumstance.
and circumstances.
Lordship.
And that money was lying in your account since 23/5/2019.
But
And you may not be a public servant, but a public servant can be implicated in a trial with the aid of 120B.
But Lordship, the 8-part charge sheet is absolutely, in fact, the FIR does not mention.
This
the-
statement is enough for this to whether to go for further hearing or not. This page 38 is clear.
But Lordship,
Have you
this-
made any statement? Let us see your statement as regards that money. Your statement is that,
it's a personal transaction. And in fact, it predates the.
and that man, this is not
Lordship,
Art.
the Lordship will kindly see. the-
art. So far, this court is concerned, not entered any.
Lordship, the allegations are December 2020 to January 2021. Although
No,
they
that
state,
is why I read your petition. Right?
Lordship.
I read your petition. That is why I took you to page 36.
But one aspect I did not.
That
mention,
during the period 2019 to 2020.
there's anomaly. They are
That
saying in the
we are not appreciating evidence.
evidence. I understand, Lordship.
If you have, you know the parameters.
Lordship.
Hard.
But Lordship, only one aspect, section 27 of the IPC, the inbuilt protective provision which contemplates situations like these. The wife, even if we assume, yes, wife has received that money, or so far as the complicity and implication is concerned, 27 IPC deals with
We, the
that.
482, we are not going into that aspect, complicity or all this.
But charge sheet
Okay.
is silent, Lordship. Absolutely silent. In fact, Lordship will kindly come to page 35. The language that
is
has
Matter
been.
of trial that will
Oh,
be done.
that is a statement of the IO.
To confine to.
It is not a judicial person.
Lordship,
Heard, Mr. I have seen it. Heard, Mr.
Y Kothari. Y Kothari.
Y. Kothari, Learned Counsel for the petition, and Miss M.
M. Kumar.
Kumari, Learned Standing Counsel. CBI for the respondent. First of the petitioner has stated that she is a qualified dentist holding BDS and MDS degrees and carries on professional private practice in Guwahati. Post of para. The petitioner's husband, Dr. Bijay Kumar Shaw, retired,
Now, yes. now
was
about-
serving in Oil and Natural Gas Corporation as a medical officer since 1996. Full stop. Dr. Bijay Kumar Shaw has since retired from service.
Lordship, not sure. Suspended as of now,
Okay,
but he's
will
yet
not say
to.
that.
I think a
Para.
repetition to that effect. is
An
pending.
FIR on a first information, a first information report was lodged on 4/5/2023 before the HOB means
The branch.
head of branch, CBI Guwahati, alleging inter alia that during the period 2019-2022, Dr. Bijay Kumar Shaw, the then Deputy General Manager within bracket MS, ONGC Jorhat, Assam, entered into a criminal conspiracy with para 4 আছে, Dr. S. Tamuli, a contractual medical officer in the ONGC Jorhat, and Sri Jodumani Hazarika, proprietor of Messrs. Kiran Physiotherapy Clinic, and abused, and the two ONGC officials abused their official positions by fraudulently generating requisition slips for physiotherapy treatment at Messrs. Kiran Physiotherapy Clinic without the knowledge of retired beneficiaries of ONGC and their dependents. Full stop. In furtherance of criminal conspiracy, such criminal conspiracy, Sri Jodumani Hazarika had claimed false and bogus bills on the basis of requisition slips issued by Dr. Ostitwa Tamuli and duly verified and certified by Dr. Bijay Kumar Shaw. Post of para. After investigation, the said FIR was registered by the CBI as regular case number 06 within bracket A stroke 2023-ZUW. Para 6 for us. Post of. The petitioner was not initially arraigned as an accused in the said in the aforementioned FIR and aforementioned FIR. Post of para. After obtaining prior approval under Section 17A of the Prevention of Corruption Act 1988, against the two ONGC officials, investigation was carried out, and upon conclusion of investigation, a charge sheet under Section 173(2) CRPC, right, charge sheet number 225/2024, was submitted against on 26/12/2024 against the three accused persons, already named in the FIR. Full stop. In addition, the petitioner has been charged as the fourth accused person. Full stop. Para. It has been submitted that the only allegation against the petitioner was to the effect that she received a sum of rupees 3 lakh on 23/5/2019, which the investigating authority is seeking to equate with proceeds of crime. Full stop. Para. On being surseated, the petitioner submitted an application before the special court of what? Which court?
Lordship,
Which court?
Lordship,
Special,
special CBI.
before the court of
Number 1.
special judge CBI, within bracket special court, CBI Guwahati, seeking her discharge. Full stop. The investigating or the prosecution agency, CBI, submitted its objection to the prayer for discharge post of the special court by an order dated 11/9/2025. Rejected the petition filed by the petitioner and proceeded to frame charges against the petitioner under Section 12 of the PC Act and Section 120B within bracket 2 of the IPC. To stop. On 11/9/2025, right?
Lordship.
Full stop. Para, the petitioner has asked that the transactions, the alleged transactions in question were during the period from December 2020 as January 2021, and transaction by which the petitioner, the transaction in respect of which the petitioner was arrayed as an was surseated was of 23/5/2029. Full stop. According to the petitioner, the sum involved in the transaction dated 23/5/2019 is a repayment to the petitioner from the surseated accused person, Mr. Jodumani Hazarika, proprietor, Messrs. Kiran Physiotherapy Clinic, which is located where?
Jorhat, Lordship.
At Jorhat. Full stop. Para. The allegation against the petitioner's husband, one of the allegations against the petitioner's husband, Dr. Vijay Kumar Shaw, was to the effect that he had received undue advantage of rupees 3 lakh from Sri Jodumani Hazarika in his wife's account as quid pro quo. Full stop. In the surseat, full stop. Investigation was with regard to fraudulent bills generated towards physiotherapy treatments by Messrs. Kiran Physiotherapy Clinic to ONGC against 313 requisition slips within bracket credit note of mostly rupees 27,440 per patient. Full stop. investigation, according to the charge sheet, the investigation revealed that during the relevant period, that is from 1/4/2019 to 31/3/2022, medical services of ONGC empaneled Messrs. Kiron Physiotherapy Clinic, Sinamora, Jorhat, as one of the empaneled clinic to provide physiotherapy treatment to medical beneficiaries stroke patients of ONGC, Jorhat. On the basis of requisition slips, within bracket credit notes issued by Medical Services stroke Dispensary, ONGC. Full stop. The charge sheet further mentioned that investigation had established that Dr. Vijay Kumar Shaw, page 34, A1, and Dr. Ostitwa Tamoli, A2, prepared all the 323 requisition slips within bracket credit notes in the name of retired stroke active beneficiaries of ONGC Jorhat and prescribed physiotherapy treatment of 14 days with 2 sittings on each day. So all 323 requisition slips were certified, stroke verified, stroke countersigned by accused Dr. Vijay Kumar Shaw within bracket A1. Full stop. Out of 323 requisition slips, 271 requisition slips issued in the name of retired beneficiaries were found to be fake. Full stop. Para. The charge sheet has been filed stating that during the period 2019-2022, Jodumoni Hazarika, A3, entered into a criminal conspiracy with Dr. Vijay Kumar Shaw, A2, A1, and Dr. Ostitwa Tamoli, and submitted fake stroke force bill in respect of 271 requisition slips in the name of retired beneficiaries of ONGC without their knowledge and consent. Full stop. The charge sheet further provided, the charge sheet further mentioned as under page 38, this para. Page 38. Page 38. Para whether a private person in aid of section 120B IPC can be charged in a case involving offences under Prevention of Corruption Act. Stop. Whether whether the petitioner was a part of the conspiracy entered into by the other three accused persons, Jodumoni Hazarika, Dr. Vijay Kumar Shaw, A1, Dr. Ostitwa Tamoli, A2, and Jodumoni Hazarika, A3, during the period from 2019 to 2022, is a matter which can be established only at the trial. Post of such appreciation is not, evidentiary value of the materials is not to be gone into. Evidentiary and probative value of the materials collected by the investigating agency and parts which are parts of the charge sheet are not to be gone into in a petition under what is the new section 528 of Bharatiya Nagaric Kahani. Full stop. In the light of the discussion, above discussion, and for the reasons mentioned herein, this criminal petition is found to be unmerited and the same is not entered.
My lord, item number 19, my lord, is a motion matter, my lord. I omitted the interim prayer. extremely sorry, my lord. It was typographical mistake, my lord.
Bring it tomorrow.
That may be allowed, my lord. Tomorrow I'll,
Okay, Mr. B. Burwal and counsel for the petitioners submitted that may be allowed to file an additional affidavit seeking seeking an additional relief
for stay, my lord.
of stay. Full stop. The praise the Lord. You make a mention, list sought for by Mr. Burwa, list the case tomorrow.
Tomorrow, my lord. I'm deeply obliged.
Watching the criminal petition, my lord, for washing of the charge sheet, my lord, only see the FIR, my lord, FIR file only to cover the case against the complainant husband and their families, my. The instant FIR on, my lord, page 12, my lord.
Yes.
Page 12, my lord, with the translated copy. And page 16, my lord, particular, my lord. Earlier, my lord, the family member of the petition, I want to file initial FIR, my lord, for killing their cousin, my lord. And
I could not.
the husband, my lord, first kill the cousin of the petitioner. Then, my lord, they file a FIR, my lord, at page, my lord, the
12.
page 12 subsequent FIR only to cover the cases, my lord.
Let me read. Nazma,
12.
Break to state of family of the below mentioned.
Is the vernacular portion? Can I write?
Family of Iman. Engaging college of Mukti. Accused of it. Okay, this is Nazma Begum.
Nazma Begum.
Hmm.
And page 22, Nazma Begum, my lord, husband Safiquddin. And first FIR on page 22, my lord, Nazma Begum, Abdul Basit, my lord.
Can you read page 22?
My lord, says, kindly see, they supply.
You read from my petition.
Yes, my lord, I cancelled the copy, my lord.
No, the legible copy of the vernacular has to
Yes,
be
we have.
there. Can you read this?
Yes, my lord.
Hand it over to PP. Can she read?
Same,
Can she
my
read
lord.
it? How these illegible copies are passed through the registry? No, no, no. I'll put a report. Ask for a report from the registry.
I translated the copy, my lord.
No, translated copy
My lord,
is
can you
for.
see this certified copy they supply, my lord.
Can you read the charge sheet? Can you read page 28, 27 and 28?
Yes, my lord. They supply, my lord. Can you see? This is the original certified copy, my lord. This is the original certified copy. They supplied.
Certified copy then means what?
Already.
Why this?
Only true.
Why that call? Writer? Copyist.
Copyist.
Why the post of copyist are there?
My lord, kindly see that, my lord, they supply such type of copy, my lord. My lord, may.
We'll ask for report.
They used to do photostat and give it, Lord. Xerox copy they supply.
They used to give Xerox copy,
Xerox
neither
copy.
20. What do you want?
My lord, can you see that copy, my lord? They supply us, well. This is they are 35 copy, my lord. How?
We don't understand what to do. What you are seeking here?
Passing of the charge sheet, Lord.
FIR charge sheets,
Yes, my lord.
which are not readable. Will you should notice at this stage?
Lordship.
My lord, readable 35 copy may be issued, my lord.
Will observe,
Direct the.
Lordship.
Direct
trial
the-
court should furnish. Heard
Xerox.
Mr. A.J. Atia, learned counsel for the petitioners and Miss A. Begum, learned additional public prosecutor. So the respond number 1 state first of the state criminal petition is preferred, seeking, setting aside and quashing of a charge sheet. Of charge sheet number 222 dated 37/2021, submitted in connection with Murajar Police Station case number 226/2021 within bracket PRC number 408/2025, and for staying of further proceedings of PRC number 408/2025, presently pending before the court of Learned Additional Chief Judicial Magistrate Hojai Hunkodev Roper. Full stop. Para, on going through the copy of the charge sheet annexed to the criminal petition. No, para, issue notice returnable on so and so. As Ms. Begum has appeared accepted. The formal notice steps upon respondent number 2 by speed post within 2 working days from today. Post of para, on going through the copy is of what are the copies? First information report dated of Murajar Police Station case number 123/2021 and charge sheet number 222/2021 filed in connection with Murajar Police Station case number 226/2018, it is found that the copies are illegible and not readable. Full stop. Para, Mr. Atia has also shown the certified copy of the same, which are also illegitimate and not readable. Full stop. Para. Register judicial shall take necessary steps for a report as regards acceptance of the criminal petition by the public filing section. Post of register judicial shall also take necessary steps, provide also to take necessary steps to intimate the trial courts for providing legible and readable certified copies of the case papers to an applicant. We don't read.
This year,
The prayer for interim relief is kept, is to be considered on the returnable date.
3001.
Before that, let scan copies
Can copy.
of
Is there?
case
As sir stated, Lordship, it will be in
TCR of which case?
PRC case number, Lordship.
ERC case number so and so. Within bracket Can copy read in bracket legible. Be called for.
May it make 127, my lord.
27.
2701. Plus
Item 15.
Yes.
Maybe please, Your Lordship, page number 4, question of FIR registered as
Where is the FIR?
page number 16.
Is numbers. This is English, right? This is the subject.
Translation, Lordship, what they have written in the translation, Lordship.
Okay, let us read them the particular, the original copy. Teaching with due respect, the subject cited above must refer back to state that myself, I am writing this complaint to bring to your attention. A case sitting, there is a husband I recently experienced. First February, I had entered in a relationship with Kiran, which one still living relationship. First February, the harassment, legal sense of living relationship, sitting, 4 lakh. The brief of the case. Northern Affairs here. Yes, Miss Begum.
Yes.
Only notice, Lordship.
No. Come to
That's
page
okay.
21.
Wait,
Last line. In fear of that,
Lordship, I have
she has concealed some of the alleged
some alleged
person
person.
documents in the apartment used to lock him outside from outside whenever she goes out for shopping.
Which
Who is the victim? Third,
we have to
Mr. N. Boru. N. Boru.
Yes.
Learned counsel for the petitioner. And Miss.
Your Honor, this case is presently fixed before the Learned Court of Additional.
Wait. A. Begum, Learned Additional Public Prosecutor. For the respondent number 1, Thomas, State of Assam. Post up. The instant criminal petition is preferred, seeking setting aside of within bracket the first information report lost and registered as Bochista Police Station case number 598/2023. Why is so many typing mistake? Registered under sections is 17 of silo and 2 or not and 2 SARS it's dated 3/4/2024 file submitted in connection with Bochista Police Station case number 598/2023 and Roman 3. The criminal proceedings of PRC case number 2009/2024 are corresponding to Bochista Police Station case number so and so presently pending before the Court of Learned Additional Chief Judicial Magistrate Kamrup. Full stop. Para. The respondent number 2 had lodged a FIR as the informant had lodged the FIR alleging cheating and sexual harassment against the petitioner. Full stop. Para. From the FIR, it is noticed that the petitioner and the respondent number 2 as informant were in a living relationship and they were staying together in an apartment during the period from 1/2/2023 to September 2023. Full stop. The informant, the respondent number 2, that's informant, had alleged that during that period, the petitioner took an amount of rupees 4 lakh on loan with a promise to repay. Stop. In the charge sheet, it is mentioned that the petitioner and the respondent number 2 as informant were staying at an apartment willingly in a living relationship with family approval. And they used to introduce themselves as husband and wife. Full stop. In the course of investigation, it was revealed that whenever as the respondent number 2 as informant had an apprehension that the petitioner would flee away without paying back the borrowed amount, she used to conceal documents of the petitioner in the apartment and to lock him from outside whenever she would go out for shopping. Full stop. Para issue notice returnable on so and so as Begum. Respondent number 1 steps upon 2 by speed post 2 working days. Having regard to the materials on record, it is good. Is the view that the petitioner has been able to make out a privacy case for an interim order. It is ordered that further proceedings pertaining to PRC case number so and so presently pending before the court of so and so shall remain suspended till the returnable date.
4th February, 4/2.
Highly obliged.
Item 16.
May I please? That are pertaining to.
You may be a good case. We'll call for a scan copy.
Yes, ma'am.
It is like the same thing. Suicide in Sri Lanka.
Sri Lanka.
We'll call for the scan copy.
Till that, nothing.
No, there is a suicide note.
Suicide note original copy is not received by the IO. Original
Let us
copy.
have it. Heard Mr.
B. Foucault.
B. Foucault, learned counsel for the petitioner, and Mr. R.
Kaushik.
R.
Kaushik.
Kaushik. No, 1 R was double R. I forgot.
Double R.
R. Kaushik, learned additional public for the respondent number 1. So stop. The present criminal petition under section 5 TNSS is preferred, seeking quashing of the FIR registered as Punari Police Station case number 304/2020 1 and the search sheet number 51/2025 submitted in connection with Nari Police number 3,000. So, as per the FIR and the charge sheet, the petitioner is accused of an offense under section 306 IPC.
304B.
304B.
498/304.
304B. Suspicious circumstance, 7 years.
7 years.
Allegation of demand of dowry.
Yes.
These three ingredients. The petition has also sought setting aside and crossing out the proceedings of PRC case number 123/2025. Presently pending. Presently pending before the Court of Learned Judicial Magistrate First Class at Soraideo. Issue notice returnable on so and so. The scan copies of PRC case number so and so be called for. As Mr. Kosik.
Along with case diary.
Correspondent number 1.
Along with case diary.
Along with and
Case
case
diary
diary.
is file already charge sheet submitted. It will come along with.
It will be a part of the.
Part of the.
As Kosik, correspondent number 1, correspondent number 2, speed post. 2 working days. Not yet, not yet. 304. Two of the ingredients are there. Suspicious circumstance within 7 years.
Within 7 years.
Presumption will operate 113 or what?
113 million. 3B.
Only thing is that demand for harassment of dowry or cruelty.
Yes. After a available.
We have fixed a date.
28 January.
8 January. And interim prayer will be considered.
Okay, prayer for interim relief is kept for open for consideration after receipt of the scanned copies of the ECR.
Item 17.
Mayor, please allow. Relevant portion of the FIR is at page 15, translated.
Page
15.
50. 15.
115.
15. Hajar Ali Sheikh Mithun Roy. Witness number 1, Muslim Ali, the driver, no driver, does not accused, who is the owner of a vehicle given by witness number 1. Complainant got an offer, a trip for transportation house about 6 months before embassy. Complainant other tribute the witness 1 handed over the phone. Owner of the cows.
Situation is like that. First, complainant, both accused and complainant, they are owners of vehicles.
Accused also has a garage.
He is a garage. He has got also a vehicle.
Yes.
Witness number 1 is the driver of the complainant. Prior to the incident of that cattle movement, his vehicle was in the accused garage prior to 4 months. He didn't pay the required amount, my lord. Bills I have enclosed, my lord. Bills maybe totaling, it will be around 80,000. Last page, the calculation is there, page 48, my lord. And page 45 and 46 is the
Yes.
parts. Vehicle has already been.
Garage. His vehicle was placed for repairing, and now he is connecting something.
Yes.
I mean,
Kettle.
saying, yes, kettle. Heard Mr. S. Sharma and consumer petitioner. And Mr. R. Kaushik, learned additional public prosecutor for the respondent number 1, state of Assam, Postop. This criminal petition under section 5 to 8 BNS for seeking passing of an FIR registered as Kokrajhar Police Station, case number 20/2025 under sections page 17. And a search sheet, search sheet number
60/2025
60/2025 submitted in connection with Kokrajhar Police Station, case number so and so. The petitioner has also assailed an order dated 12/3/2025 whereby charges no, sorry. Where is the charge for me?
Charge sheet, lords will find it page
Okay.
26.
7/10/2025 whereby charges under sections 318 within bracket 4 stroke 316 within bracket 2 BNSS have been preferred against the petitioner and the proceedings of PR. Any PR case number?
PRC case number 155/2025.
Presently pending before the Court of Chief Judicial Magistrate, Kokrajhar.
Additional Chief Judicial.
Additional Chief Judicial Magistrate. Additional.
Additional.
Okay. Sir, I issue notice returnable on so and so as Kaushik 1 steps spun number 2 by speed post. Let scan copy of PRC case PRC number 155/2025 be called for. From the materials on record, comma, it has emerged that the informant, respondent number 2, placed his vehicle in the garage of the petitioner for repairing, full stop. According to petitioner, comma, he did not release the vehicle after repairing as the respondent number 2 informant did not pay the repairing charges, full stop. The respondent number 2, that's informant, has alleged in the FIR, has entirely alleged in the FIR that the petitioner employed his driver for transportation of a set of kettles, and during the course of transportation, comma, the vehicle belonging to the petitioner along with the driver was intercepted and the driver was arrested and the vehicle was seized. Full stop. The petitioner has contended that the two incidents have no interconnection. Full stop. It is ordered from my interim that the further proceedings of PRC case number so and so presently pending before the Court of Additional Chief Judicial Magistrate, Kokrajhar, shall remain suspended till the returnable.
4th February, 4/2. 4/2. Item 18.
Lordship may kindly pass over the matter for the time being.
Any case, my lord, NDPS commercial quantity.
NDPS commercial quantity. What is the pair here?
My lord. They are seeking, my lord.
What?
Dima,
Custody.
my lord,
This as an owner,
as an owner.
and he was an accused. He's an accused.
Charge-sheeted accused,
Charge-sheeted accused.
my lord.
Commercial.
Commercial quantity.
Prosenjit Roy. What is the impugn order?
Order is at page 52.
Secret chamber. Engine box. 1,50,000 Yaba tablet. Yes, madam. And you don't have knowledge. 1,50,000. So it must not be very small. The chamber must be big. Driver cannot construct without your either explicit permission or implied permission. Then
In this matter, I am not an engaged counsel. So,
after vacation, then
Oh.
on the prayer of Ms. So-and-so, and council put a petition, release the case on the January 1st.
7-1.
What is that? Biswajit. Something. Biswajit.
Biswajit Roy, perhaps.
Item number 20.
Yes, Mr. Hussain.
Yes, my lord. This
What? What quashing?
FIR quashing, lordship.
FIR quashing.
Lordship, petitioner are, there are 5 petitioners, lordship.
5 petitioners.
4 are permanent
Let us
resident,
have the FIR.
lordship. Page 23 is the.
23.
Lordship, 23 is the.
Prakash Chobe.
Prakash Chauvel, lordship.
Okay, let us read.
Married, lordship.
28 1 p.m. I received unknown call informing me that a relative of my younger brother Arun Tiwari, Anju Tiwari, Anshul Tiwari, Aparajita Tiwari Pandey, Sanjay Krishna. These are the 5 petitioners.
These are the 5
5 petitioners here.
Yeah, lord.
Waiting near Lonpuria Tiniali Bypass Road, Tinsukia, for a talk of compromise regarding the ongoing divorce case and another domestic violence case pending in the Tinsukia. Having discovered this fact, I, along my friend, went to Lonpuria Tiniali Bypass Road for my receiver. I saw. Oh, yeah, and for them to So what happened to Chobe?
Lordship, what,
Chobe ji.
lordship, what happened?
Arvind Chobe.
Arvind
Ah,
Chauvel.
There were what? Domestic violence case against him
Domestic,
and
lordship.
divorce case.
3 cases are pending in Haryana.
3 cases.
3 cases are pending, lordship. Daughter-
Haryana.
Haryana.
Means the wife belongs to Haryana.
Wife belongs to Haryana. Petitioner number 1 is the father
Uh-huh.
of that wife, lordship.
Okay.
2 is the mother.
Arun Kumar Tiwari. He is what? Father.
Arun Kumar Tiwari is the
Father of the wife.
wife, lordship. And
Anju Tiwari. Mother.
mother, lordship.
Anshul Tiwari.
Brother, lordship.
Brother. Aparajita Tiwari.
Sister, lordship.
Sister.
And
And Sanjay Kumar Mishra.
Sanjay Kumar Mishra is the uncle, lordship, maternal uncle, lordship.
Yes.
They are, and
It
I have a
seems-
specific, lordship, statement that they were not present, lordship. I have a specific statement, paragraph 3, lordship.
Paragraph 3.
On the day of such alleged occurrence, lordship, Paragraph 3 is my specific statement, Lordship.
Arunachal Pradesh government,
One is the
housewife,
Lordship.
unemployed, government teacher,
Arunachal Pradesh, Lordship.
all
Petition of
all theories are from Arunachal.
the original
She is
from
a-
Haryana, Lordship. And
All
5
Madhya
is
School,
the
Rewa.
Madhya Pradesh, he is working there, Lordship.
Or anything as regards your presence in Haryana?
Lordship, I am reciting that specific statement on of
Huh.
Lordship so far there, Lordship.
Anything to substantiate?
Affidavit is Lordship.
What are the cases pending?
Cases pending, Lordship, there are.
Show us.
Lordship.
28.
Page 20.
It starts from 28.
Page
28, man.
28. This is what?
26 is domestic.
Okay, under DV Act.
Lordship, 26.
Before Tinsukia.
Lordship,
In Tinsukia.
it is by the wife of this present informant, Lordship, but page 26 is one case pending, Lordship.
Huh?
Page 26, Lordship, kindly have, Lordship.
Himadri Tiwari.
Lordship, daughter of the petition number 1. This is Haryana, Lordship. pending.
Versus Arvind Kumar.
Domestic violence, Lordship.
This is DV.
DB, Lordship. And page 27 is the another case, Lordship. There is 125 CRPC, Lordship, by the daughter.
125 CRPC.
Lordship.
Hmm.
And Lordship, page 46 is the Lordship case lodged by brother of the informant in Haryana, which was dismissed for restitution of conjugal rights, Lordship. Page 46.
So 2 cases.
3 cases, Lordship. Another is, Lordship, page 63, Lordship. That is under 498A, Lordship. 3 cases are pending in Haryana.
60?
Page 63, Lordship.
Page 63.
63.
This is the number.
This NBW is already issued. That is the cause bone of contention.
Heard Mr. M.K. Hussain, learned counsel for the petitioners, and Mr. R.R. Kosik, learned additional public prosecutor for the respondent number 1 state. Full stop. The petition number 1 and the petition number 2 are the father and mother of one. It's Himadri Tiwari. Full stop. The petition number 3 and the petitioner number 4 are a brother and a sister of M.S. Himadri Tiwari, whereas the petition number 5 is an uncle of Ms. Himadri Tiwari. Full stop. Para. The one, Arvind Kumar Chobe. Chobe is a brother of the respondent number 2, that's informant, Sri Prakash Chobe, who had instituted the FIR registered as Tinsukia Police Station case number 371/2025 on 11/10/2025 under sections case 24 last of underlying corruption. After a preliminary inquiry caused into the affair lodged on 29/9/2025 post of Para. The Miss Himadri Tiwari had instituted 3 cases against her husband, Arvind Kumar Chobe, under the provisions of DV Act, Domestic Violence Act. Within brackets, COMA-142 -2023 bracket close. Under section semicolon under section 125 CRPC within bracket MNT -185 -2023 bracket close, and under section 498A IPC page
Lordship.
CHI bracket of it -12 -2024 bracket close in courts of competent jurisdiction in the state of Haryana, and all the three cases are presently pending post op in the case comma CHI -12 -2024 under section 498A comma the court of learned judicial magistrate Palwal on 7/1/2025 issued non-bailable warrant of arrest against Arvind Kumar Chobe to secure his appearance. Post op. Projecting the above facts, the petitioners have further contended that on the alleged date of occurrence, comma, 28/9/2025, comma, none of the petitioners was present at Tinsukia. Full stop. Para issue notice returnable on so and so. R. Kaushik, Mr. Kaushik, respond number 1, steps upon respond number 2, speed post. Having regard to the projections made above, it is ordered that further proceedings in connection with GR case number 772/2025, comma, corresponding to Tinsukia Police Station case number 371/2025 shall remain suspended till the returnable date.
Supplementary list, item 38.
Have you seen why I
Yes,
have
my
said?
lord, I may be allowed to withdraw.
Mr.
T. Sheikh, my
T.
lord.
Sheikh, Learned Counsel, at Mr. T. Sheikh, Learned Counsel for the petition, and Mr. R. Kaushik, Learned Additional Public Prosecutor for the respond number 1, State of Assam. Full stop. Mr. Sheikh has submitted that as the petitioner has the remedy of preferring an appeal under the proviso to section
Section, my lord, 419.
419.
Justice to appeal of BNS. And 378 of CRP.
BNSS.
Yes, my lord. 378 of CRP.
That I know.
Yes.
Problem is with BNSS.
Yes, ma'am. 419.
It will take me years to remember. Which? I1?
419, my lord.
419. No. No. You are acquitted in ZR case number.
Yes, my lord. Case under.
This petitioner is the Babul Soikia.
My lord.
Who is the FIR?
FIR, my lord. His number, my lord, 30.
Babul Soikia. He was the informant.
Yes, my lord.
And CGM is the trial court.
Trial court, my lord. CGM is the.
So, appeal will lie to session judge. So, you are the informant and you were beaten up.
Yes, ma'am.
So, you are a victim.
Victim.
So session judge,
Session Judge.
519 proviso, we don't have any business here.
419.
419.
419.
So
I
we
see.
don't have any business.
Yes, ma'am.
Mr. Sheikh has submitted that in view of the remedy of appeal under the proviso to 419 Bharatiya Nagorik Surakha Honita 2023 available to the petitioner hearing, the petitioner who wants to withdraw the present criminal revision petition in order to avail the appellate remedy before the jurisdictional appellate forum. And he is not facing this criminal revision petition, come out with liberty. So Mr. Kosik, additional public prosecutor, has approached the said submission, post of in view of the above submission made by Mr. Sheikh, learned counsel, the petitioner, this criminal petition is allowed to be withdrawn, with liberty to the petitioner to avail appellate remedy before the jurisdictional appellate forum under the proviso to section 419 B and S.
Highly obliged.
Item 39.
In this matter, the conducting counsel, due to some medical emergency, has to leave the court's premises.
Medical emergency.
Yes, Lordship. Therefore, kindly the matter may be
What
part
is
of.
the offense?
Lordship,
Please, Honor.
I do not have any instruction on this case.
Okay. 1 minute, 1 minute. Mr. Kosi, you are not a party here?
Not a party.
Your judgment is here. TCR. Then this judgment. Here case number and so it. Okay, concurrent finding under 138. What do you want?
Lordship, kindly the
Is
matter.
a matter of matter is also suspend of sanction. Okay. When? After vacation.
After vacation, immediately after opening of.
On the prayer of Miss
P. Bora, Lordship.
P. Bora, Learned Counsel for the petitioner, place the case on video. 9.
9. Deeply obliged, Lordship.
Item 41.
My pleasure.
NIA. Check this honor.
Lordship petitioner,
What?
before this honor, for recalling the NB and PNA.
In order. NIA case 2022. What is the check amount?
Check amount is 3 lakhs.
3 lakh.
Lordship, the petitioner first April.
After receipt of summons,
Lordship, kindly come to the page number 23. My first April.
23.
23, Annexure C.
Complaint absent return after appeared. So you appeared.
Lordship appeared.
Allowed on bail. Right?
Lordship, kindly come.
Then?
Lordship, kindly, may I read, my lord, for a moment? Part peruse the case record. Learned counsel for the accused submitted that part payment of the check amount has already been made to the accused, and both sides have amicably settled.
That is merit.
Lordship, yes.
We are in NBW.
Lordship, NBW.
We are in NBW or for quashing of the.
No. NBW as well as PNA.
So
And
that
they are-
part is not material
Lordship,
now.
I'm showing this because only on some payment of some
That
money.
cannot be an excuse for non-appearance.
Lordship, Lordship, may kindly come to the page number 25.
Job training.
Page number 27, my lord.
25 job training.
25, there, he is out of station.
Here put up.
Lordship,
Accused absent. Hard allowed.
Lordship,
For cross of PW.
Lordship. And come to the page number
Then-
27.
Issue. Absent with steps.
Page number 27.
Hmm.
Accused absent without step. Lordship,
Earlier date with step.
with step. On
Yes.
that date itself, my lord, 28/3/2024, the NBW was issued, my lord. First date, my lord,
ENA.
28/3/2024.
Yes, Mr. What do you say? ENA?
The complaint
I-
is otherwise,
Oh, because
the other side has to be harder.
no, the procedure part, otherwise, both,
Available to,
the complainant is more interested in money otherwise.
yes, madam. Going by my learned friend's submission, madam, he has paid half of money. Likely.
I am ready to pay, my lord, but he's out of state. He now presently is serving. That's why.
However, so far my knowledge goes, my lord, he will show that the illegality in this DNA order, my lord. At least.
Because we cannot,
Yes.
without any, you may say, come to the court without any reason.
Yes.
But to pass an order, I have to show a reason.
Yes, madam. That's right.
Nothing is there. So I have to look for myself. I have to help myself. And period is long.
That is long, madam. It seems, my
Is
lord,
it
that
not?
order is not.
So
Lordship,
you are in
yes,
job training for more than 1 year.
Lordship, PNA was issued on 10/10/2025.
What about,
Lordship, Lord.
what excuse you have? What excuse you have
Whether the NBW,
for your repeated absence?
but the engaged counsel did not inform him properly, my lordship.
That is not.
Absolutely no ground at all. That is no ground at all.
Petitioner, so I am,
By engaging a counsel, your duty is not stopped. That has been deprecated. That ground. Good night. Third, Ms. P. Bora, learned counsel for the petitioner. Full stop. The petitioner has been facing trial in a complaint case, NI case number 02/2022, presently pending before the court of Chief Judicial Magistrate Tinsukia, the trial court. Full stop. The complaint case has been instituted under Section 138 Negotiable Instrument Act 1881, as amended, on the ground that a check issued for a sum of rupees 3 lakh from an bank account maintained by the petitioner in favor of the complainant stood dishonored on the ground of insufficiency of fund, full stop. After taking cognizance, the trial court issued process against the petitioner for appearance. Full stop. It is stated that on 4/11/2022, the petitioner appeared and sought for his release on bail. Full stop. The trial court allowed the petitioner to go on PR bond of rupees 8,000, in default, to jail hazard. Full stop. The petitioner was also asked to pay a cost of rupees 500 due to his non-appearance on previous dates, which resulted into a delayed proceeding. Full stop. Para. It is a case of the petitioner that during the subsequent period from 7/9/2023, the petitioner could not appear before the trial court, and he asked his engaged counsel to apprise, because he had to undergo job training in Gujarat, and instructions were accordingly placed to his learned engaged counsel. Full stop. However, on and from 13/2/2024, no steps on behalf of the petitioner was taken in NI case number 02/2022. So as a result, the trial court ordered for issuance of non-bailable warrant of arrest against the petitioner on 28/3/2024. Full stop. Subsequently, on 10/10/2025, when a report was submitted to the effect that the warrant of arrest was returned without execution. When a report was submitted to the effect that the warrant of arrest had returned without execution, due to the reason that the accused could not be found, the trial court issued order for proclamation and attachment. Full stop. Para. The condition precedent for initiation of an action. Like trial. It has been submitted on behalf of the petitioner that though during the earlier period, the petitioner could not be present before the trial court due to reasons beyond his control, the petitioner has undertaken that he would appear regularly in the trial henceforth without any default. Full stop. He has thus sought for recall of the order of PNA as well as the warrant of arrest. Full stop. Para. The condition precedent for initiation of an action for issuance of for proclamation is prior issuance of warrant of arrest by the concerned court. Full stop. Before a proclamation is issued, the court should have reasons to believe. What is the perimeter provision in BNSS of 82? Oh, 84.
84 man.
Before a proclamation is issued, the court should have reasons to believe. Within bracket, whether after taking evidence or not, bracket close, that a person against whom warrant was issued has absconded or is concealing himself, and that the warrant cannot be executed. Full stop. The satisfaction could be subjective, but it cannot be without any material basis. Full stop. Only after recording such satisfaction, the court can direct publication of a written proclamation requiring such persons to appear at a specified place within a specified period. Full stop. It has been observed in Srikant Upadhyay and others versus State of Bihar, 2024 SCC online SC282, that to reach a satisfaction that a person is absconding, evidence is required to the effect that the person concerned was knowing that he was wanted and also about pendency of warrant of arrest. Such evidence was apparently insofar as the issuance of non-bailable warrant of arrest is concerned, the court is to be guided by the parameters set forth in Section 90 ENSS. As per as the petitioner herein has projected that has undertaken that he would regularly appear before the trial court henceforth and would not make any default. And having regard to the order dated 10/10/2025. Comma, which is found to be not is found not in conformity with section huh? 90 PNS. Comma, this court is of the considered view that if the petitioner is allowed to appear on the next date of next date tomorrow in a period of 15 days from today by keeping the warrant of arrest in abeyance. The same would facilitate an expeditious conclusion of the trial under section 138 negotiable instrument. The complaint has been lodged by the complainant in NI case number so and so, primarily for recovery of the take amount. So the appearance of the petition at an early date would facilitate the process. So is ordered accordingly. It is therefore ordered that the warrant of arrest against the petition shall remain in abeyance for a period of 15 days, and the petitioner shall appear before the trial court within such period of 15 days. So it is further observed that if the petitioner such appearance submits files an application, is released bail, comma, the trial court shall consider the same on its own merits and in accordance with law. Accordingly, the order dated 10/10/2005 whereby the trial court has ordered for proclamation and attachment is set aside and passed.
Publish.
Item 42.
Maybe Lordship, this is an application for quashment of NBW Lordship. Allegation is POCSO 6 Lordship. And the petitioner cooperated till 17/2/2025. And thereafter he went to the Karnataka for work Lordship. And the learned counsel of the petitioner for the
none of them is a good ground.
Lordship only 18/8/2025 the
when you defaulted
18/8/2025 Lordship.
First default.
Yes, Lordship. And from 17/2/2025 to 18/7/2025, I remain present with steps, Lordship. Only
Heard Mr.
R. Islam.
Petitioner R.R. Kosik, additional public prosecutor for the respondent state. Most of the petitioner is standing in a trial, standing as an accused, is facing a trial before the court of Special Judge POCSO Kamrup Amingaon, within a special court in Sessions SPL POXO case number 39 stroke 2021. Full stop. A charge under section 6 of the Prevention of Protection of Children from Sexual Offences Act 2012 POXO Act has been framed against the petitioner upon his appearance on receipt of summons from the special court. Full stop. The petitioner has projected that when after appearance, the petitioner applied for bail, he was allowed to go on bail by an order dated.
I'm not,
Are you really on bail or not?
I'm on bail, Lordship.
Where is your statement? I have not seen anything. That is why. If you are an absconder already, I don't know.
Lordship, para 3, Lordship, I have stated.
Allowed to go on bail. Full stop. However, on and from 18/8/2025, the petitioner could not appear before the trial court, the special court, due to reasons beyond his control. It is stated. It is stated. However, another. Mr. So-and-so, Land Counsel for the petitioner has submitted that the petitioner is ready and willing to appear before the special court on the next date of
17/1/25.
posting, 17/1/2025.
6, Lordship.
2026. So, however, the petitioner has an apprehension that during the period, during the interregnum, he might be apprehended and would be taken into custody in view of the order or in view of issuance of warrants of arrest against him by the special court. Full stop. The charge the petitioner is facing before the special court is serious in nature. And yes, which provision of POXO Act says 1 year or 2 year? POXO Act. And as per section (35) we need to get 2 of the POXO Act, the special court is section in section so it has been provided that the special court shall complete the trial, as far as possible, within a period of 1 year from the date of taking cognizance of the offence. Full stop. In view of the undertaking given by the petitioner that he would regularly appear before the trial, special court henceforth without any default, and the same would facilitate an expeditious conclusion of the trial, this court is the considered view that for the period till 17/1/2026, the warrant of arrest issued against the petitioner can be kept in abeyance so that the petitioner can appear before the special court on 17/1/2026, without any apprehension of arrest, and to prefer an application seeking his release on bail. Full stop. It is ordered accordingly. Full stop. It is further observed that in the event petitioner appears before the special court on so and so date and submits an application for bail, the special court shall consider the same in accordance with law and on its own merits. This order
Lovely.
disposes of the writ petition, criminal petition.
Item 43.
Yes, sir.
My lord, petitioner has challenged the proceeding under section 420, 406 IPC, my
40.
420 and 406, my
Let us see the FIR first.
lord. At page 22, my lord, that is translated copy, my lord.
Page
22, my
22.
lord, annexure 1.
Field officer meet with
Vernacular part is at page 20.
legible or illegible?
Eligible, no?
Very. Field of-
Incident dated, my lord, 2014, my lord, 28/12/2000, FIR lodged on 6/6/2020. 16, my lord.
Huh?
There is no explanation regarding the delay, my lord, so far as. And subsequently, charge sheet submitted after.
2000.
And he is not a officer of the
60.
KBI Khadi village. From the industry, he is not a authority.
Huh?
He is not an authority. a
Who?
Petitioner, my lord. As per allegations, they
If
have
he is not
stated
an
that-
authority, then makes out a case of cheating then. If he is not an authority, that makes out a case.
Because, my lord, he has no connection with them, my lord. And in the charge.
And in
sheet,
spite of that, you have deceived all
in-
these
in-
villagers.
In the charge sheet, my lord, the.
You have
police
cheated all this. How much amount?
In fact, that is the
22
case, my lord.
lakhs, my lord.
Huh?
In fact, that is the case.
Yes.
22 lakhs they have.
20
allowed.
only.
And for disbursement of loan and others, my lord, 22 lakhs, my lord.
22 lakhs. How much you have duped?
For sanctioning that, if they have paid 22 lakhs, that the loan amount should be above 1 crore, my lord.
Officer, may receive a total amount of 22 lakhs. Must fall for me of
Can depend there from different.
bank account of the petitioner.
Account number is.
You have waited since, let us have a scan copy.
My lord.
You have waited since 2014. You wait for some more months.
I have not
Maybe
waited,
an
my
ultimate-
lord, I have received the summons only in the month of December, my lord. And case is fixed on 2012-25, my lord. Then I have come to know, my lord. There is-
People are avoiding court. You have seen the last 2-3 orders. Years together. After 4-5 years, they come for recall of
Police have charged.
warrant of arrest.
2016, police have charged.
Along petitioner RR Kosik. One, huh? I can lick.
And another thing, my lord,
Petitioner is seeking quashing of criminal proceedings of what? PRC number
PRC case.
2402/2024. Presently pending before the Court of Subdivisional Judicial Magistrate within bracket as Kasar as sales or trial court. So submission notice returnable. Let us scan copies of PSC Swens call for issue notice. Returnable on so and so. As Kosik 1 tips response number 2.
So far as allegation, my lord, 420, 406.
I have seen that
Obliged.
let the LCR, TCR come. I don't think any document has been recovered. For transaction, bank transaction, some document is to be recovered to see that, yes, they have said that some money has been deposited. and 22 lakhs. That is a bit high.
For a disbursement of loan. Obliged.
Next day.
3001. Obliged. Item 21 for orders.
21. What are those?
There, please, your lordship.
Gupta issue notice petitioner, no coercive action against the petitioner. Neither, we have to wait then. Third, Mr.
R.K. Mohanto.
R.K. Mohanto, petitioner, R.R. Kosik. Respond number 1 state. In view of office note dated 29/5/2025, the matter is placed before the Lower Jima Court to ascertain the status of service upon the respond number 224. Is the case after 4 weeks.
Lordship, there is.
The interim order past order shall continue till the next date of list.
Lies.
Item 23.
There is no representation on behalf of the petition, review petition today on call. Release the case on a date immediately after the ensuing winter vacation.
Item number 24.
Criminal appeal.
Yes, my lord, the service upon respondent number 2, that report.
What is the offense?
Offense, my lord, 8
POCSO.
of POCSO, my lord, and
Section
354 IPC.
8.
Allegation is that.
Yes, Mr. Public Prosecutor.
We'll take
Report.
instruction, my lord.
Report
Or we'll take instruction.
from officer in charge. DKMAD. Appellant.
Yes.
R. Kosik. Respond number 1, state of.
My lord, in the IM, my
Mr.
lord,
Kosik. Learned traditional public prosecutor is to shall obtain a report as regards service of notice from the officer in charge, Yaspur Police Station, and to place the same before the court on the next date of listing. Yes.
my lord, there is an IM, my lord. In that IM, we may be allowed to take space.
IA is not been shown here, my lord.
I is not shown. This will suffice. This will suffice. After appearance or service, same thing.
Obliged.
Place the case on switch.
Obliged.
Item number 25.
Yes, why it has come in Kothari revision petition is filed by a petitioner. Judgment in criminal appeal. Why
Wait, please, your lordship.
no, I just you have been leniently treated.
Lordship, due to
You have been leniently treated.
Lordship, due to miscommunication of instruction, your lordship, the step could not be taken. Your lordship, I plead for a
No.
last opportunity.
You have not been asked to deposit
Lordship,
by the previous order.
Your lordship, I have already undergone 3 months out of the 4 months imprisonment imposed. on
it?
me. Yes, your lordship. That's why it
Okay.
was stayed, your lordship.
Okay. But no step.
Your lordship, That is due to a miscommunication on our part, Your Lordship. Today we shall take the steps.
Mr.
S. Talukdar on behalf of Mr.
Mr. Here's the office note dated 4/11/2025. So Mr. S. Talukdar, Learned Counsel for the petitioner has submitted that the petitioner be allowed 2 days time to take steps for service of notice upon the respondent.
Your Lordship, the stay on execution may be, execution of imprisonment may be extended. For the last order, it was
In
on
reference to order dated 26/9/2025, the prayer is allowed as a last sunch. So stop. Lease the case on so and so. The interim order passed earlier shall remain, shall continue till the next.
Item 26.
P. Shinha. P. Shinha, Learned Counsel for the petitioner is present. Here is the office note dated 7/11/2025. Full stop. Issue a reminder for the case records of CR within bracket NI, case number 09/2017. Full stop. List the case. The petitioner is allowed 2 days time to take steps for service of notice upon the respondent without fail.
I think the usual course, I think that has been received by the respondent, I think. Usual course one. Registered post, they have not received. Usual course.
No step at all. No step at all. Despite enjoying stay.
I think it is there. They have sent by registered post also.
I have checked. Registered as well as usual.
Yeah, on the first time, it
In
was not.
reference to the order dated 26/9/2025. 2 days without fail. The interim order passed earlier shall continue till the next date of listing, with an observation that if no steps is taken, no steps are taken within the next 2 days, the interim order, continuation of the interim order will be examined on the next date of listing.
Right.
2nd February. Item 27.
And screening petition, training for crossing of FIR, Sanmai Police Station, you notice these days. This means suspended until further of the court. Now, what is the issue here? You have entered appearance.
Yes, my lord, I am entered.
Service is complete.
Service is complete. I am appearing for the informant, my lord.
Okay.
Just one submission I am just going to make. The stay order is entire investigation has been stayed, my lord.
What to do? I cannot modify now.
My lord.
Until further of this court.
Yes.
Not for me to modify now. You make an application, that is a defined issue.
My lord.
Mr.
C. Paul.
C. Paul, petitioner, and Mr. R. Kaushik, Learned Counsel for the Learned Edition Public Prosecutor for the respondent number 1, State of Assam, is present. Full stop. Mr. T. Chakraborty, Learned Counsel, has submitted that he has entered appearance for the respondent number 2.
Yes.
Full stop. Para, all the respondents are represented. Full stop. release the case on so and so for in admission.
A fixed date maybe.
Giving, I am not giving.
Lord,
Your lordship, interim order may be extended.
Until further
Yeah,
order,
yes, sir.
shall I modify it
No, no, no.
till the next date of listing?
No.
obliged.
First read the order, then make prayer.
Item number 28.
Why this has come?
This is a delay condemnation petition, Lordship.
Heard, Mr.
DS Deccan.
D.S. Dekal, Learned Counsel for
DS
Petition. B.
DS.
B. Because of this instant application is under Section 5 of the Limitation Act 1963. Seeking. How much delay?
81 days.
Seeking toleration of delay of 81 days in preferring the accompanying criminal revision petition. Issue notice returnable on so and so steps upon the opposite parties by speed post within 2 working days.
Item 29.
Four thirty,
I am-
preferred by the seeking suspension of sentence issue notice return. Yes,
Yes, my lord, appellant is the very old man, my lord, 70 plus. So on this ground and considering the nature of evidence of the trial court in this case, I pray before your lordship suspend the sentence. Already 8 months have undergone out of 5 years.
first let us see, sir, what is the offense.
Offense is attempt to murder,
Yes,
No injuries,
no injury.
huh?
no injuries.
No injuries. Where from you are saying?
My lord, the victim statement, as well as my lord, I
Point out.
statement.
Heard, Mr.
Hey, Paul.
A. Paul. Point out from the LCR.
My lord.
Learned counsel for the applicant appellant. And Mr. R. Kaushik, learned additional public prosecutor for the opposite party, thus respondent state of Assam. Full stop. The present application is preferred by the applicant appellant seeking suspension of execution of the sentence passed against him and for his release on bail. Present application under section 430B and SS. Para. The applicant as the appellant has preferred the accompanying criminal appeal. Criminal appeal number 239, 2025 against a judgment, an order dated 23/04/2025 passed by the Court of Additional Sessions Judge Rongia Kamrup Trial Court in Sessions case number 70/2018. Full stop. By the judgment and order dated so and so, the trial court has convicted the applicant appellant for the offenses under section 307, IPC and section 341, IPC. Full stop. For the offense under section 307 IPC, the applicant appellant has been sentenced to undergo rigorous imprisonment for 5 years and to pay a fine of rupees 5,000, in default of payment of fine, to undergo simple imprisonment for 1 month. Oh, full stop. Remove P41. P41 part 2 remove radio. Full stop. Para, it is averred that since the date of the judgment and order dated 23/4/2025, the applicant appellant is undergoing the period of sentence, and as on date, the applicant appellant has spent More than 8 months.
About 8 months.
Uh,
About this.
More
More than 7 months.
near about 8 months.
Yes.
Of the sentence. Full stop. It is contended on behalf of the applicant appellate that the victim himself in his testimony before the trial court had deposed that he did not receive any injury.
But directly didn't
No, I'm
say.
led. You tell
But
me.
but directly didn't say, but the thing is that he was brandishing the dao, then people came and caught him.
Okay. Himself said that, deposed that the applicant appellant was brandishing a dao, and it was at that time, he was caught by passers-by.
People who were working in the
He was
field.
apprehended by passers-by. Most of there were, and there was no attempt from the applicant appellant to cause assault on the person of the alleged victim. Full stop. Having considered, taking into consideration the fact that the full stop. It is further submitted that where you have stated how age,
Lordship,
where you have stated.
the title,
It
page
is
3.
further stated that the applicant appellant is aged about 70 years as on date. Full stop. Taking into consideration the facts that the applicant appellant is aged about 70 years and he has spent about 8 months out of the
Five.
sentence period of
5 years.
5 years.
5 years.
And from the testimony of the alleged victim, it primarily emerges that there was no injury on the person of the victim. The possibility of acquittal on benefit of doubt cannot be ruled out altogether. Full stop. Accordingly, it is ordered that pending disposal of the accompanying criminal revision petition, the sentence, execution of the sentence passed against the applicant
Paresh Bharali.
appellant shall remain suspended and the applicant appellant shall be allowed to go on bail subject to 5,000 with 1 surety of the like amount to the satisfaction of the trial court.
Disposal of the appeal.
I have already dictated. Have you not heard? Have you not heard? I have said, na? Till disposal of the accompanying criminal appeal.
Obliged.
Item 30.
Yes, 30. Why? Criminal petition.
Taken on,
Await service notice. Interim order passed earlier. What happens? Order has been passed for status quo. What is the service status?
step was taken on.
Notice has been issued. Neither ID nor so and so. 10 copy. case record has been received. Wait, heard Mr. G. R. A. Mubarak, Motaku, how you spell it? Mottaki, learned counsel for the petitioners, and Mr. MP Goswami, learned additional public prosecutor for the respondent number 1 state. To stop await for the service report in respect of respondent number 2. List the case on so and so. The interim order passed earlier shall continue till the next set of list.
2nd February. Item 31.
Neither educate nor answer notice of return.
31,
Issue
my
notice.
lord.
First and so and so. 10 years.
Legal aid.
Boxo.
Yes, legal aid council, my lord, is appointed, my lord.
And Huh?
Written as per the list, cause list, my.
Where?
Item 31, my.
Appointed.
Yes, my lord.
Written
Mr.
objection
P.
is also
Stoichia,
filed.
Legal aid and council for respondent number 2.
Pavitra Singh.
Pavitra Sagapara.
Where is legal aid counsel? What engaged? Does he not had duty to appear before this court? Yes, Mr. Bora. Immediately after reopening. LCA received.
LCA received, my.
10 years.
10 years, my.
Boxo.
Fixed sums.
Section 4.
And moreover, Lordship, the margin of error is not given to the, that because age is proved by only a transport certificate, no birth certificate.
That is bit more on merit.
Yes, that's why I just pointed.
BP Bora, appellant. And Mr. R. Kosik, learned additional public prosecutor for the respondent number 1, State of Assam, are present. Yes, Miss, as the learned counsel has appeared on behalf of Mr. B. Stoichia, learned
Legal aid council.
Legal aid counsel appointed on behalf, appointed to represent the respondent number 2. In view of as prayer is made on behalf of the respondent number 2 or by the learned on behalf of the learned legal aid counsel, the respondent number 2, list the case on
4th February.
No, the January. IA
21. 21.
Deeply obliged.
Item 34.
Stoichia,
May it please your lordship.
Amit. Mr.
R.K. Mohanto.
R.K. Mohanto, petitioner, MP Goswami,
Yes.
respondent number 1 state. To stop, await for the service report. Respondent number 1, 3.
34 files, we are not there, man.
Huh?
In 34. Our name not shown.
Not shown.
Yes,
Okay, not shown. Await for the service reports in respect of respondent number 1 and 2. This is the case on so and so. Interim order passed earlier shall continue.
Obliged.
2nd February. Item 35.
What application?
Delay 11 days.
Heard
delay.
Ms. B. Sharma, learned counsel for the applicant. Under instant application under section 5 of the Limitation Act 1963 is preferred seeking condonation of delay of
11
what
days.
offense? What offense?
341, 6 months imprisonment.
Condon.
Yes.
GR case.
GR case.
And Mr. MP Goswami, learned additional public prosecutor for the opposite party, Kama State. Huh? The instant application under section 5 of the Limitation Act 1963 is preferred seeking condonation of delay of 11 days, which period of delay had occurred in filing the accompanying criminal appeal under section 415 B and SS against a judgment and order dated 22/9/2025 passed by the Court of Sessions Judge Golaghat within the trial court in Sessions case number 05/2024. Full stop. The trial court has convicted the applicant for the offense under section 341 IPC, and the applicant has been sentenced to undergo rigorous imprisonment for 6 months and to pay a fine of rupees 2,000 with default stipulation.
Yes.
Oh, no. 2 offenses, right?
2 offense.
324,
wrong.
341, my lord, is 1 month.
Has been convicted for the offenses under section 341 IPC and section 324 IPC. So stop. For the offense under section 341, the appellant has been sentenced to undergo rigorous imprisonment for 6 months and to pay a fine of rupees 2,000, with default stipulation. Full stop. For the offense under section 324, he has been sentenced to
324, 6 months, 341, 1 month.
undergo simple imprisonment for 1 month. Full
No, my-
stop. Both the sentences are ordered to run concurrently.
Concurrent.
Full stop. Para. As I have gone through the statements and affirmations made in the instant application, explaining the delay of 11 days, more particularly paragraph 4 thereof. Full stop. Having gone through the same, having gone through the reasons for delay, this court is of the view that the petition applicant has been able to show has been able to show sufficient cause for the period of delay of 11 days. So accordingly, the instant application is allowed the registry to register the accompanying criminal appeal and thereafter, release the same for admission.
Date because I've referred a application for suspension of sentence only months.
You were out, I think.
At present out.
Raised immediately.
Item 36.
Registered the appeal immediately, huh?
Wait, is it 511 days delay, Lordship?
Private party, okay. Then issue notice first.
Yes, Lord.
D. Ghosh. Applicants. MP Goswami, opposite party number 1. State of Assam. Section 5, Petition Act 63, 1960. 511 days in filing the accompanying criminal revision petition against an order dated 3/2/2024 passed by the Court of Special Judge Morigao in session within brackets special case number 13/2022 by the order dated 3/2/2024, the special court has framed charge. So after framing of charge, what is the stage?
Lordship, it's now it's for evidence, but in this case, there were 2 FIRs because both the
What
cases
is
are
the stage?
evidence stage.
How many? In between 1.5 years, how many?
Only
Witnesses have
one,
been examined.
only one, Lordship, only one.
In charges against the applicant under section 120B, 489A, 489C, 489D, IPC. Fake currency.
Take currency, my lord.
Issue notice, returnable so and so. Steps as so and so has appeared. I think you can represent both.
Yes.
Huh? For response number one, opposite party number 1 and 2. Huh? No formal notice. An extra copy.
Let
We
the
need to-
notice go. We will also let the notice go. Madam.
Issue notice.
Issue notice.
I have said
Yes.
returnable and so and so.
Yes.
You have appeared for both.
Yes.
That is IO only.
Yeah.
Ah.
That's from,
You can appear.
because of the
An extra copy. An extra copy. 2 days.
kindly see the name of the petitioner, madam. That his conduct is otherwise wonderful. madam.
Lordship, they came for something else to buy, they brought the money.
This
They
is
came,
madam.
but their money is being snatched away. This is the reason 2 cases,
This is-
they have lodged in FIR, Lordship.
489 A, B, C. This is an assault on the economy
Assault on the
and the nation.
Lordship, they were.
This is an assault,
yes, madam.
not on a person,
But
on the country.
country, madam.
We'll see.
Yes, Lord.
Supplementary list, item
Thank you, ma'am.
45.
There is no representation on behalf of the applicant to the on-call. I'll list the case. নতুন বছর দিয়ে দিব ফার্স্ট উইকত
Right, Your Lordship.
How many days?
77 days, man.
GR case or?
Oh, my lord.
No, madam, it's complaint case.
Complaint case.
Oh, then we have to issue notice. S. Sahu. Huh? Or do any state? No.
State is my
Formal
party, madam, formally.
No, in the criminal division petition, state is not a party.
Yes, my lord, party.
No.
Or
In-
they are in the original petition, not. In the,
In the IA, you have made a party.
my lord, my lord.
In the criminal division petition, you have not made a party state. সাইবেল লিখি দিব
It is there.
সাইবেল লিখি দিব
Petitioner,
টাইপ লিখি দিব
response number 1, madam.
7 days লিখি দিব জাজমেন্ট লিখি দিব ইস্যু নোটিস রিটার্নেবল অন সো এটা যেহেতু অপোজিট পার্টি নাম্বার 1 এমপি গোস্বামী কোনটো গুড হা তালিকা ও নহয় Okay.
Third party.
I was looking at different files.
Okay.
Lordship.
I have
One.
given different files.
Response number 1.
Opposite party number 1 লিখি দিব এমপি গোস্বামী steps opposite party number 2 report 77 days দি দিব returnable দি দিব
Public.
No.